Matters stand adjourned to be listed after 2 weeks. Okay, pen call, one good. Number one. No, personal appearance. Mr. Hi. My pleasure. The last occasion, chief was called for the Chief General Manager Romia, my lord, regarding clarification of the matter. Yes, yes. I remember. That is why I have taken up this matter as the first item. They have other business to do. You are the chief manager?
Sir, I was the chief manager and
Okay,
right now.
anybody.
Yes.
Yeah. Now, you see, what I wanted to know one thing.
Sir.
Here is a case where the person concerned did not apply for internet banking. Then, in that case, how is the internet banking applied in the State Bank of India?
Sir, this is the circular as per circular dated 28/4/2015. Sir, this is a copy for the Honorable High Court. According to this circular, sir, online registration.
Yes.
Online internet banking registration can be done without branch visit, sir. In this case, what is required? Number one, ATM card details and ATM PIN of the customer and the registered mobile number with the bank where the OTP will go so that the registration process can get completed. So the branch, there is no branch intervention in regard to registration of internet banking without branch visit, sir. And on this modus operandi, this particular case has happened, sir. The ATM card details was compromised and the mobile operator has ported the mobile number which was registered with the bank without due verification. So as a result, the OTP went to the fraudster and everything has been done. So internet banking got activated.
So anybody who has the details of the ATM card along with the ATM pin can have open the INB.
Sir, provided the mobile number is registered with the bank. So it's a dual factor authentication. First is the ATM pin, sir. Second is the OTP received at the mobile registered with the bank. In this case, the fraudster got hold of the mobile number. There are same SIM which was registered with the bank through porting. Due date verification was not done as far as my knowledge by Airtel during porting. इसलिए OTP सर मोबाइल में चला गया, सेकेंड ऑथेंटिकेशन हो गया, and ATM card and the internet banking got access. Sir, this is the details. How the INB activation got activated with the IP address and all details as sorted by SP Cyberdrome. We have provided these details where and how it has got activated by the fraudster using the same mobile. So this is the detail.
But you also need to have the ATM.
ATM, sir.
ATM card is required.
ATM card details
And ATM pin.
Yeah.
And you have a circular also to report if there is anything. And you keep it on hold for some time, the amount.
It was
No, you have a circular for that. I think not your circular. I think it's the Reserve Bank circular.
regarding the hold of the amount which was transferred to the concerned department. I'll have to look into.
No, you have to. You give an option that within a particular point of time you have to inform, and if you inform, then it would not go.
Sir, probably, sir, but 24 or 48 hours. So I will have to check. I will just get back to you.
Mr. Mannan, have you looked into my judgment in that case? The Justice B.D. Agarwal judgment. The judgment was delivered by me. It was a case filed by him, a writ petition where an amount of 6 lakhs was taken away.
Lordship judgment.
Hmm?
Your lordship judgment.
Hmm.
I have.
And around 6 lakhs was taken away from his account. So he immediately informed. Thereupon, the ombudsman did not pay, did not give any direction. The matter came before me. In the meantime, he made an RTI with the State Bank of India. And the State Bank of India, on the basis of a Reserve Bank circular, say that they keep this money for a hold for a particular period of time. And thereupon, unlike UPI, this money of internet banking is kept on hold for some time. Therefore, you have these three things, the NEFT, then IMPS, and there is another one. What is that? RTGS. So, therefore, if you go for this IMPS, it goes immediately. The other two, they keep on hold for a particular point of time. So, in their reply to the RTI, it was mentioned that they kept on hold. They did not transfer the amount till the information was received. And as such, the moment they inform that the liability is accrues upon them, so they should not have given it. So I passed that order. I think the division bench also had upheld that judgment. But here is a case. Let us go for a simple example. If a person steals any amount of money from you, you can claim the money from him. And if a person steals the money to another person where the other person was also responsible, you can claim the money from him. But in the case where the other person is not responsible, can you claim the money from the state bank?
fact, I'm just passing off a judgment of the Supreme Court. Just pass off. Not if here para 11 and 12, exactly similar thing has happened.
Yes.
This
Let us-
judgment para 11 and 12, your lordship will kindly put exactly more or less similar type of a thing has happened.
Let us read it.
In the above, I'm not reading the fact. In the above backdrop, the key question to be considered is whether, without the school's account being linked with net banking facility, any money from the bank account could have been sought out by the miscreant. The obvious answer to this question has to be in the negative. As concurrently found by the State Commission, the Banking Ombudsman, and also the NCDRs, the bank has rendered themselves liable by enabling net banking facility by linking the individual account to school principals to the school's account. The only reason why the State Commission as well as the NTRC has limited the compensation sum to 1 lakh was because of the perceived complicity of the principal. But the charge sheet filed by the police revealed how the fraudulent transaction was made by the two charge sheeted accused, and more importantly, the police did not find complicity of the principal of the school with those fraudulent transactions. The banking ombudsman to declare that the bank was at fault, which facilitated the loss of the school, but declined to order the refund as the demanded sum was beyond the pecuniary jurisdiction of the banking ombudsman. Considering the above, the denial of compensation corresponding to the extent of school loss by the State Commission as well as NCTRs would not, in our view, be justified. The question then is whether the bank should be asked to compensate the school for the entire loss, though such fraudulent transactions through suspect. In this context, it may be noticed that when the siphoning of the large sum of 25 lakh was first detected by the school staff, the official complaint was not lodged immediately, and only on the date the complaint was filed with the bank authority. Whether the bank manager was verbally informed on the date of detection or on the next day is an aspect which is difficult to conclude conclusively, and therefore a consequent siphoning of rupees 5 lakh by the next may have been occasioned by the contributory negligence of the school authority. But insofar as the loss of 25,000 is concerned, the complainant cannot be held responsible directly or even vigorously, either as an institution or the principal as an individual. We are therefore the view that the respondent bank should be directed to compensate the school to the tune of 25 lakh transferred until here what has happened, your lord? The whole thing was basically not done by me. It was by the fraudsters. Somehow they got my phone number, and as per my person concern, he also stated that the SIM was deactivated and they, I think, used another my number and did all stuff.
No, then
That person
why I'm saying. First and foremost, if you see paragraph 2 of the judgment, this happened prior to 2014. At that point of time, internet banking was not permissible without the aid of the bank. Now, if internet banking was permissible without the aid of the bank, if a person commits a fraud and the state bank cannot be made responsible, you cannot assign any reason as to how the state bank can be made responsible. How can this court impose upon the state bank to make the payment? Here is the case of 2014 where the internet banking must have happened out there with the concurrence of this. And there was no internet banking facility applied. But here is the case where they have done so because they have provided that facility of an internet banking without the person's visit to the branch. Then in that case, can you hold the bank responsible?
somebody will have to take the responsibility.
No. Would it be the responsibility would be of the person who are the accused? Or would the responsibility be of the person who, the Airtel? Because they have helped in the swapping of it. Or was there a contributory negligence on the part of the bank with the Airtel and those persons concerned?
That as per police report, that is, but as per
And therefore, you see, this is a case which went to the this state commission. And there was an evidence taken in that regard as regards contributory negligence and everything. But can this court, unless you show that yes, the bank was responsible, direct the bank to make the payment, or solely direct the Airtel to make the payment, wouldn't that come within the ambit of a contributory negligence and I expect for determination to be done by the state court commission or the commission who needs? I have full sympathy for you. I know that yes, that money has been taken, but can this court put the responsibility upon the state? That is the problem. Earlier to this particular circular, I was under the impression that for a purpose of applying for the internet banking, you need to.
No, even I feel nowadays they have an app. You have to download the app and then put the particulars and then get the internet banking and the
No, that I know. I know that app. You are referring to
app
that.
or whatever bank they have their
So
own
they have an app. That is apart from that. To get that app also, you have to go. I was under the impression that one needs to go to the
No.
bank.
is not that I know.
No, if that be so,
That means
if
I have to
anybody can
download
do,
the app first.
because there might be a question of contributory negligence on the part of you in sharing the debit card details. Because without the debit card details, it couldn't have been done.
Yes, there are two things here. Why it has happened. First is that there was the ATM withdrawal by the person. There are two things very clear. First thing is that his PRT amount, the provisional pension amount was deposited. 9 lakh something was there. Immediately after the deposit, there were two ATM withdrawals by the person. He only used the ATM as far what I have asked him and told him. Use the ATM, he is not, no, he don't even use UPI. But anyway, so he used the ATM for two times. The day, 1 day prior to and 2-3 days later of use. And the date he used the ATM, second time, the very next day, the whole thing. And there could have been something in the ATM, I'm not sure, because it is the police fact. But from there, the most probably this ATM card or debit card, whatever it is.
Because if you
must have
see
been
the circular,
compromised to such things.
no, Mr. Mannan, if you see the circular, what is required from the ATM card is, you
I
have a
have
copy
not
of the circular?
the circular.
Yes,
That's
Mr.
compromised.
Chief Manager, give it to him.
Sure.
What do you require out here is
The account number is required.
account number is okay. Account number anybody
CIF
can have. The
number.
CIF number one can have get from the passbook. Anybody in has the passbook, or from the bank itself they can get it.
Branch code
Branch code also,
also
there's
can
no
be-
problem with that. Registered mobile number
Number.
one has
yes,
got.
that can be.
Then
we
you
can
kindly look out here. Thereafter, if I have an ATM card, online registration without branch visit, in the next screen, enter the card details, card number, valid, true, and expiry date. You see, this card number has 2 dates. We have 2 dates. One is valid from
and one is expired.
and the expiry. But that would not appear unless there is a picture captured in the ATM itself, or there has been sharing of this card, or the details of this card having been shared. Date, card holder's name, PIN, and the characters visible in the box.
Correct, sir? The box.
What box?
Captcha, sir. Captcha.
Oh, that captcha.
Okay.
Then it is required to be submitted. So these card details there might have been some contributory negligence, or may not have been. But these are questions of facts. Can this court decide and impose upon them? Unless you show. Think about it. We'll have it on some other day. But that is the thing.
Yes.
That
that's
is why I asked the chief manager or him to come to explain, because your counsel would not be so expert to explain this aspect of the matter. Because that is a very important aspect. Because can you now proceed on the basis of this petition? Okay. Have a look at
Yes.
if you can pinpoint them.
Now let me take the structure.
Yes,
How-
yes,
what
pinpoint them. Then obviously the court will impose the burden.
Also,
But
we
if
have
you
to now have
can't-
a look into the what was the Airtel scheme thing also. That also have to have a look into that.
Because what he says,
But because he said that there was a issue with the pin, sorry, the SIM card.
Yes, sir.
no, that is what happened. The Airtel permitted swapping.
Without the
Due diligence.
No, not swapping. What is that?
Porting, sir.
The porting. Your mobile number must be from some service. Airtel
Ported to
permitted
Airtel.
that
Hmm.
to Airtel. This
And
is how
they
the
did not
porting was
verify-
done.
They did not
They did
verify
not, yeah.
the
Without
Ah.
due diligence, they handed over the SIM to the proper.
And that is
And
how the porting happened. And that is how
All-
your person,
OTP went
Went
you
to
were
that
getting
same
the
mobile number.
you were getting the connection, just for example, idea. It became Airtel. And Airtel did not verify. Airtel only looked into as to whether the earlier payment was made or not. Once it is being paid, it happened. So that is there. Has Airtel filed an affidavit? You are
Yes,
Airtel?
they have filed. They have- Just account, but I don't know what is the amount in the account. No, that has not been given by the police. Yeah, it's the account and feed the account. So money has been whether money is transferred from the account to something that is okay. And
No, not on that. I am not on the other aspect. I am only on the aspect as did you make the necessary verification? Because the porting, you can't go one fine morning and go and say that I want to port.
we have done the proper thing. Now, if the SIM belongs to the daughter of the petition,
The
Now-
mobile number.
mobile, daughter of the this wife is in operation since 11th November 2003. That is the first SIM she got. This was given to the bank. And when this shopping has been done, that mobile
Porting.
uh,
Earlier it was in whose name? Earlier what was the service provider?
they,
No, it can't be a porting then.
they have
It may be a case of wrongful
that
a loss of the card.
card or
Now, was it porting or loss of the card?
porting card.
It
Loss
was
of the card or maybe the card is not working. Then my lord, he can get a
But for that, Airtel requires that you need to submit a verification,
that is there. That is the investigation protocol right.
no, along with an identity card.
Yes. You're also trying to investigate that I did that part.
Whose investigation? No, I am asking about your affidavit.
Give us that.
To me, in your affidavit.
No, affidavit is not document found it.
Huh?
Otherwise, we have to give it.
You have not filed?
No, we have filed the affidavit. We take it the point of jurisdiction.
No, don't take all these jurisdiction basis.
And number two, my lord,
We'll consider that jurisdiction basis is out and
but that, my lord,
you can pinpoint the claim to Mr. Rao.
Dr. T, what happened? The fraudster, he got the SIM. So now the SIM will he get the SIM immediately, my lord. And after 2 hours, that SIM got activated, the new SIM. And for 48 hours, that SIM cannot be worked. No SMS can be received. After 48 hours, the SMS is received. This is, my lord, I think mostly this is done to stop any because the moment that earlier SIM is deactivated, but the new SIM is given, and the earlier SIM deactivated, then the person will go to the bank. Suppose he has not.
No, but Mr. Roy, you need to bring this aspect of the matter by way of an affidavit. Because we'll have it next Thursday. Have the affidavit and file it. And Mr. Counsel, bring these things and that document which he tried to produce by way of an affidavit, so that this can be put on record, and then we'll. Pursuant to the order passed by this court on 14/11/2023, Mr.
Sushanta Da.
So and so, the learner, the deponent, did you sign the affidavit?
Yes.
Wait. Mr. Sushanta Das, the then chief manager of the State Bank of India Rangya branch, was present before this court. During the course of the hearing, he placed before this court a e-circular issued by the General Manager, Alternate Channel, State Bank of India, to the Chief General Manager, State Bank of India, whereby registration for internet banking by existing customer was made permissible through online registration without branch visit. During the course of hearing, he further submitted that there was no fault on the part of the State Bank of India, and as there was a registration so done on the basis of the material, on the basis of the requirements as set out in the e-circular, the account of the petitioner became activated for the purpose of carrying out internet banking. This could have also heard Mr. J. Roy, the learned counsel, appearing on behalf of the Airtel. During the course of hearing, the learned senior counsel for Airtel submitted that the mobile number in question was initially was in the name of the daughter of the petitioner, and upon being informed that the SIM card was damaged, oblique not working, a fresh SIM card was issued. After making necessary verifications. This court, however, finds that the said respondent number 10 and 11 have not filed any affidavit on merits and have only raised the point jurisdiction. It is the opinion of this court that the this court fixes the matter again on 23rd of November 2023. This court directs the respondent number
6, 7, 8, and 9.
6, 7, 8, and 9 to bring on record the e-circular as well as the other documents which was shown before this court by way of an additional affidavit to be filed by 21st of November 2023. The respondent number 9 and 10, 9 and 10, 10 and 11 is given the liberty to file their reply on merits by 21st of November 2023. It is made clear that if no affidavit is filed by the respondent number 10 and 11 on merits, this court shall construe that they have nothing to say on merits. And list according. The personal appearance of Mr. Susanto Das, the then chief manager of the SBI Rongia branch, is dispensed.
Obliged.
You think about
Yes.
it may be a case of contributory negligence. And if it is a case of contributory negligence, it is not for this court.
I understand. We have to go for order.
Maybe it may be a case you may have to go if you, because one thing is clear. Those accused are now very much, these people have already come to the forefront. Once they have already come to the forefront in view of the investigation, whether you can still move the State Consumer Forum would be difficult.
I do.
You may have to go for a civil suit. But if you otherwise, you can just point out, because you see, Airtel normally does not give a SIM, my SIM to you
Yes.
if you go. Even if you take my documents. The basis that can be given is on the basis of an authority.
That is not the only thing they have done. But I have come to know
That
from
is
the
why
record
we will
that
we
the
will
voter
take it.
ID card of the daughter, who's actually, while the father has been, because he doesn't have a mobile on it, that voter ID card, fake voter ID, made by the they have produced before the Airtel and Airtel.
If they don't do it, we'll pass. We'll make some observation. It will help you.
That
in
is
the-
what I think is Martyr.
I know 1 to 4.
By last order, your lordship directed the department to produce the record. If instead I talked to the IO, he is on medical leave for last 14.
Can't help you. We will construe that it today is not big.
So, and otherwise on last occasion I submitted a letter.
No,
Yes.
these letters I'm not going to go take in.
They could not.
You were supposed to bring on record that thing for which I have given you the opportunity earlier, which you have not. And as such, on that ground itself, this is bad.
On last occasion, lordship, I submitted that they could not find out the record. Because
No, I gave you the opportunity.
yes, lordship,
However, Mr. Kyle Dallin submits that the said record at present could not be traced out.
Yes.
Now tell me, how it could not have been traced out? You have done a rectification. What is this? Reassessment.
Yes.
Reassessment.
regarding the
You have done the reassessment and immediately thereupon, the writ petition was filed.
yes, sir.
Then how did you lose the records?
Lordship, what happened earlier, the office was shifted in another building while sitting.
No. Yeah, you couldn't have. You can't make this type of excuses.
No, lordship, this is the instruction.
No,
I have
Mr.
received.
Kyle, you can't make such type of excuses. Don't make this type of irresponsible statements before this court.
No, that's why I have.
No.
That's why I have-
You cannot, because here is a case where there has been a reassessment proceedings, the moment the order has been passed, he has come before this court.
Yes, Lord Chief.
Then-
The affidavit was also filed.
You have come against the notice or
No, no,
Against the notice, my
notice. Now,
sir.
how do you do the reassessment? Tell me. If you don't have the records?
no, Lord Chief. No, record was there.
No. Now, as of now, how are you going to do
That is,
if you don't have the records?
that is another difficulty is there before that. But
No, then on that ground itself, we have to set aside the reassessment notice on the basis of your very statement that you don't have the records.
that's why
Isn't it, Mr. Goenka?
on last occasion,
If you have challenged the notice
My-
and he doesn't have now the records to even, if I set aside or if I dismiss your petition, then also he can't do the reassessment proceeding because he doesn't have the records as he says.
that is the fact, Lord. That's why
Means
I often written in
recently a Bombay High Court division bench judgment has also come, Mr. Goenka,
Yes.
on your point 151.
my lord.
that is fact, Lord Chief. That's why I have obtained written
2 o'clock.
instruction from the department.
I'll give you time till 2.
Yes, Lord Chief. That is fact. I'm not denying that. Sufficient opportunity was given to the department to produce record.
So under such circumstances, if there is no records, can you do the reassessment proceeding?
Not
No.
possible. Not possible.
So it has to go.
That's why I obtained the written instruction from the ITO.
You have any document to show that there is no records?
Lord Chief, on last occasion I submitted a letter
Hmm.
from the
I didn't keep it. I gave it to
no,
Brad.
it is the record.
No. If I keep, I always mark it. You have given this reason for issuing. No, this only you gave it. Only one line page
No, Lord
on
Chief,
that day.
only,
The
through
online request for approval of JCIT is submitted as approval is granted.
yes,
Notice
that
on
was
the AI is generated as so and so. There is nothing mentioned as regards records, no records.
one page later, Lord Chief, was I received through email. That was stating
Very
that
well. We have the email.
they could not find out the record. And only one page was submitted where approval of the
We set aside the reassessment notice on the basis thereof. You don't have the records.
just Lord Chief, that is fact and this is my written instruction. This is my written instruction also.
Huh?
This is my written instruction also.
Give it to me.
Lord Chief, I from record
I've
I
not
find
been able to trace out. Person
out. On last
that you
occasion,
are asking.
one page later,
Decide that
I'll find
on
out.
that very way. How are you going to do it?
No, that is fact, Lord. So,
Only one document is there. This is good.
one document here we submitted one page of record. That is that approval was taken from the JCT.
No. They send you in your email.
Email. I'll
Get
find
the
out
email
Yes, sir.
at 2 o'clock.
Yes.
We deliver the judgment in your presence.
Yes, sir.
Huh?
Later may kindly be passed out to Sandeep.
Why?
My secret contact.
Senior not required. Yes. Did you get who was the magistrate?
Yes.
What do you propose? What should I do? Should I not issue notice to him? If I have to make some reply,
Yes. Otherwise, my lord,
so it would not be proper.
no, my lord, my lord, regarding that merit of the other part of the case, my lord, he has to, my lord, challenge that order, otherwise no remedy.
It's another aspect.
So then, in their respect, my lord, instead of taking in judicial side, let it to the
Why?
administrative side. Because if the lordship pass any order in judicial, then has to be notice goes. And notice goes to.
No, that is okay. But if I have to pass any order or pass any, or if I make any directions out here to the or make any observations as regards the manner in which he had dealt with and transfer the proceedings from Polasbury to Nongpo, this court has to deal with that.
My lord.
And am I, if wouldn't this court, can this court make any statement out here that the magistrate could not have done this in this manner? What he has done was wrong. The concerned magistrate, and in view of my order passed on the last occasion, whereby I had said to get the name of the judicial magistrate, now, would it be possible to pass any order
Against him.
or
Without
make
him.
any observations without
That will
giving
be
him a
difficult.
notice?
My lord, that will not proper.
Huh?
It will not be proper. He has to be hard.
And more particularly in view of the recent judgment of the Supreme Court,
I have seen
taking into account the Nia case.
that order has I have seen. My lord. That
Then?
order is- That's why. And not only that, my lord, yesterday I come across another order of this, my lord.
Hmm?
Yesterday I am come across another order, my lord, that is
Hmm.
to taken up, my lord, for expansion of the remark by
I have to give him an opportunity.
no, I cannot represent him, my
Huh?
I cannot represent.
No, you can't.
I can't.
You cannot represent him. But the fact that would it be proper on my part, on this part of this court,
From my
to say anything or make any observations
My lord.
now
my lord, he has to be hard.
without, as regards the order of transfer, without hearing him?
At least explanation from he is to be required. My lord, he has to make part.
Is he required to be made a party?
My-
No. I don't think he is required to be made a party. We can ask him, pass an order.
Right.
But the moment, why should I array a judicial officer in this manner? You will have
Because there
another
is a-
serious
no,
consequences.
yes, there is a Judicial Officer Protection Act, there is a act of
So therefore, I can't array him as a party. Only for making some observations or to let us give him an opportunity of hearing or ask him to submit his reply.
no, without making him party, your lordship can,
Why not? Would it be
Yes,
necessary
then-
to make him
then-
a party?
then your lordship, without making him, your lordship can call it. Your lordship, yes.
Because this court, while exercising 226, still reserve itself the power under 227.
Yes, superintending power is always there.
Yeah.
227. No, if that particular order has been challenged before this honorable court, your lordship, well, it is a not as per law, your lordship can quash it. But that is not the situation now. But order of transferring was not been challenged by anybody till now. Probably that transfer order is also filed on passed on 4/8/22, 2014.
Actually, recently I have gone across one judgment. Whereby there was a directive given for reinvestigation under 226. Sorry.
No, here, my lord, 226 year lordship can, but yet already the matter is attained finality by different jurisdiction. The matter is already acquitted. That is that after transferring matter has been, my lord, dealt to it, attain finality, no appeal filed. Really, my lord, from my point of view, my lord, maybe he has a very good case before the honorable honorable, my lord, Shillong High Court, my 462 power can be exercised, man. Because he's without hearing him, that order was passed. Without hearing the complainant.
That's a recent, it is a recent judgment, Mr. Mohanto.
My lord,
Recent judgment.
passed by
Supreme Court.
my lord. Regarding the investigation.
The Supreme Court. No. It was not. It was a division bench judgment. I forgot. I recently read that judgment.
Regarding, my lord, regarding the investigation or the
Yes. So the judgment was delivered. But the investigation was done in such a manner. Not only it was set aside, they didn't set aside, they directed, but I think it was a transfer. There was a case of in Madras High Court. It's a case of Madras High Court. Yes, I remember. In the Madras High Court, there was some minister. Yes. In fact, the Supreme Court did not interfere with that order itself. Now remember, some minister. What happened? They transferred these proceedings from one district to the other.
but it is within the world of the Madras High Court.
No. Wait. On the base, after the transfer, these people were acquitted.
By the another district court.
Another court, which had no jurisdiction. This judge looked into it, saw it, took up the matter in no challenge, and directed reinvestigation. How could this have been done? The investigation was also done false. And the matter was then
By the
challenged in the Supreme Court. And you must have seen recent live law
my lord,
things about where the Chief Justice of India had commented, we require judges like him.
that,
You must have seen recently.
Right.
That is the judgment.
Then let me, I'll find it out.
Have a look.
But
that is the case.
That case, my lord, but that will not help this case, my lord, because that is within the same, there is the another state of Madras, state of my lord, I mean,
But that judgment is not set aside till now. There was no there. You took up the matter under 227.
not set.
Huh?
Even, my lord, without setting aside the
Yes.
final judgment, how that's
This is what done. That is what I am saying.
that, my lord,
And that matter went to Supreme Court.
is it?
And the SLP was dismissed. And these were the comments which came up very recently.
Then
You must have seen it.
Then let me find it out.
In
my
live
lord.
law, these comments came, we require judges like A.C. Mutai, the Honorable Judge in Madras. He was the person who passed. He took up the matter under 227. This was some MLA or some minister
Yes, let me take the-
who had committed some crime somewhere, alleged crime. Investigation, court proceedings was going on. Somehow, through the court,
that has been transferred to the another district. And it got acquitted. Right?
Because
Yes,
this court wants that all avenues needs to be exhausted before putting him again back to Meghalaya.
yes.
Otherwise,
If
this,
there is a possibility, yes,
anything
we
can be
also
done.
feel it, my lord. Is it?
Yes, anything can be done. This court will do it.
But
But if not, then obviously I'll put him to Meghalaya.
Right.
But only thing is, let's look
yes,
into
I'll find it out. Yes, there is a good.
if this is there. And you just think about what is to be done with this person. Should I issue notice to him? Because I don't think he should be made a party. Or should I have to, or do I have to make a party? If I have to make a party, then I'll have to place it in the administrative side. Because it would not be, I don't
Yes.
want to make him a party to
No,
this proceeding.
equally, he has a protection, man. A judicial officer protection act will apply. So that's why I'm submitting it can be taken up in the administrative side.
But can I pass any
That
order
will be
after
of-
these order which I
of the
pass?
record, madam, not on the record. That is not on the this. It is without money
So
passing.
then can I comment that the transfer couldn't have been made in this manner
Difficult.
after I have got the name of the person concerned?
So that's why, my lord, you lost it. Ask me. I'm officially. I am taking it.
Yes, Mr. Khan.
My lord,
Yes. This is what came up in life. You read the judgment of Madras High Court.
Smile, bye.
This judgment by Justice Anand Venkatesh. Whereby he took up the powers under 227 without setting aside. Mind up. Yes, what do you have to say?
my lord, my submission, my lord, is that, my lord, that was a conviction on plea of victim. No appeal right under section 675, covered by 675 here. My submission, my lord, is that transferring the case from the jurisdiction of Amingaon magistrate from Palasbari to Nompo, thereafter getting the charge sheet filed, showing it is an accident case, thereafter pleading guilty, and then paying fine, and then getting out. This is the modus. This is the chain of events. So this needs to be investigated by the order. Our first prayer, my lord, all this while, my lord, we were, my lord, on the first prayer to direct de novo investigation, reinvestigation of the Palasbari PS case number 183.
No, your prayer is not that. Your prayer is for de novo investigation of Palasbari case.
Yes.
But you are not asking for the investigation of the chain of events which led to this acquittal. That is not what you are asking for.
That is not there directly in the
Right?
prayer.
Not directly or indirectly. Though
My
recently, the Supreme Court has also passed an order when you are not asking for the reliefs, not to grant that relief.
My lord, if required, my lord, I'll amend my prayer. If required. But my lord, that is my prayer as on today, my lord.
You can't make that prayer if it is not there.
Then I'll amend, my lord. I have no option. If I amend, then this court has power, my lord. Because this is the modus, my lord. This entire modus has to be investigated. And my lord, there is one prayer, my lord. Prayer number 4 to direct registration of FIR against respondent number 14 to 18 under appropriate sections of law for misusing their
Where did
offices.
the incident happen?
My lord.
Incident happened as regards 14 to 18.
Yes, my lord.
Where? 14 to 40, except 16 is Jagat Borman or whoever it is. The other three are from Mongpo.
14 is from Assam, 15 is from Assam, 16 is from Meghalaya, 17 and 18 also from Meghalaya.
So, and whatever they have done is in Meghalaya.
Right.
Then
Then
how
my
can
lord,
this court direct initiation of
my
an
lord,
FIR?
I'll amend the my lord's petition. I'll amend the prayer, my lord. Or my lord, I will come with a fresh writ petition also. That also can be done. But my lord, I cannot go to Meghalaya. There also I will not get any relief. Or my lord, since I have already made a prayer for CBI investigation of the Palasbari PS, my lord, there is one more prayer, my lord, that is generative what we put to grant any other relief. The date can give that. CBI investigation. After opening the record, if lordship is satisfied that there is some action, then my lord, to direct CBI investigation into the entire chain of things. This is the model. They got it transferred. Then they
No, for getting a CBI, you have made a CBI party? No. How can you direct
party is not required, my
Why not required? 100% it will be required. Yes.
that my lord, we have to amend, my lord. Either we have to amend or we have to fight fresh. Or we can come up with another writ petition, fresh writ petition from the brother of the
It is by the father of the
father. Brother will file my take CBI party there, have appropriate brother, will take vote, and then not here.
Mr. Mondo, without CBI being made a party, this court cannot direct the CBI to investigate.
Normally, my lord,
Because the CBI the thing has to be taken into account. Whether they would like to do it or not. Not only that, this court can very well
yes, court can direct, my lord.
direct, but without hearing them, would it be proper on the part? How do I issue a writ? To whom?
Yes, it cannot be issued.
I can't issue a writ to him, the CBI, without the CBI a party.
Normally, my lord, court direct the investigation where going on to hand over the direction to the government to send it to.
Then the union has to be made a
Yes,
party,
union has to be made a party. Union of India is the
not a party.
not a party.
No, Union of India is not a party. Union that to whom under whom
yes.
CBI works.
That because court can issue writ to the government. Court can issue to the state of Assam or Union of India.
This
And
court
they
can
will
very well issue a writ to
Yes.
CBI also to investigate.
yes,
So therefore, without the CBI or the union a party, how can this court issue a CBI? It will be as if doing it at the
no. But I am submitting in absence of suppose Union of India is made a party and that CBI is not a made a party, then direct this honorable court direct the Union of Government of India to hand it to the government, my lord, direction is needed. So suppose, my lord, it was sent to the CIT, then my lord, state of Assam is a party. So your lordship can.
if the state of Assam is a party without
CBI
CIT
is a
being
party,
made.
then your lordship can direct. But here is Union is not a party, CBI is also not a party.
Mr. Monta, you have a look at this
Definitely,
judgment.
I'll find it out. I'll place.
And also, what is to be done to this officer? How should this court, can this court pass any observations without making, because obviously making him a party is not necessary, in my opinion. But what is the course of events this court should take? If I have to pass any order holding that the transfer was illegal or should not have been passed, or he had transgressed upon the jurisdiction conferred upon him, because it is apparent he has done, and the manner in which it was done, there was some reason given would have been different, but the manner in which it was done by first portion is written by somebody, second portion is written by somebody. Is this the manner in which it is done? You just have a look into it. We'll have it again.
But actually, why these two handwritings? That has to be, my lord, answered by him only.
Absolutely.
Answered by him.
No, not only that, the manner in which because this court is going to pass some observations as regards the manner of transfer. The
My lord.
transfer, how he has done, the basic, I think anybody, a person who has just passed out the law would know this. And we are concerned about the judicial officer who doesn't know. That you can't transfer a police case from here to there.
That order is absolutely, my lord, even without jurisdiction. In such a situation, he can write
No,
the-
because another thing, while sitting out here, I could see that there are many transfers being made by magistrates at the request of the police. Saying
that
that
cannot be mine.
no, this is happening.
Even he has no power.
Not only here, many other, but not outside the jurisdiction of the state
Even-
or outside the district, outside the. But there are many cases you will find where the CGM is transferring a particular matter from Dibrugarh to Golaghat. I've seen it. I asked, how is it possible? This is how I find out many cases. This is happening. So this aspect also requires to be taken note of, and the order needs to be passed. Because you cannot transfer. The power at best can be exercised if it's an inter-district. And you need a judicial offer. Investigate. Investigation, can the CDM pass? Who is going to transfer?
That he cannot have the Senate cannot. There's no power.
And more particularly, if you see 156.1, we can bring 156.1 read with that chapter from starting from 177 to 181.
This is why, my lord, when in wrong place. Suppose, my lord, suppose, my lord, in the wrong place.
This is the judgment of justice. He did not set aside. He initiated a sumoto revision under 227.
Right.
And against that, the matter went to the Supreme Court. And the Supreme Court did not interfere. But this is the judgment. Have a look at it. Because there are reference to many other
Yes,
judgments.
that has to be, because, my lord, things are happening here now.
Yeah.
It has to be looking.
You continue, huh? This is by which it was dismissed, taking into account that as the sumoto revision is still pending before the single judge, we are now dismissing it, giving the liberty to raise all. It will occur. Including this one. So, this aspect also needs to be dealt with as to whether a transfer, because it can be only done if you, in terms of 156.1,
151.
read with 177 to 181. Because on the basis of 156.1, you can bring 177 to 181 to the fold of investigation.
Jurisdiction. Ordinary place of inquiry.
Because the investigation is in a different chapter, inquiry
Is it-
and trial are in
Trial
different
is
chapter.
different. No, that's why, my lord. If suppose, my lord, in Guwahati there is a cause of action arise. Suppose a murder took place in Guwahati, and FIR lodged in Dibrugarh, my lord. So that is, my lord, he has registered a case, my lord. But it is zero. It is called zero FIR, and he can send it. The police, after registering a case, my lord, that FIR can be sent to the place of where the actual took place, man. So that's
By
why
the police
policeman
himself.
himself. That is in because that is called zero FIR.
But do you need the ear of the magistrate?
No,
This is what is being done.
that magistrate not required in that.
Because the power of
Because
answer.
he has no power, he cannot come to the investigate. He cannot come to Guwahati and investigate the matter. They took place in Guwahati.
Hmm.
So, but here, my lord, I have seen somebody file application to the
But
magistrate.
this
and
is what
magistrate.
is happening.
That is
No,
what-
not
yes, my
many
lord.
other
That order is absolutely illegal. That, my lord, everybody
This is obvious.
obvious,
But in other matters also,
my
it
lord.
is being done every time. How do you do? What the police is doing, the police is not doing it by themselves. But what is the basis on which it is being transferred?
To the actual place of occurrence. Yes, that has to be, my lord. Under what authority? That police.
Because that is also very relevant,
Really,
which will be here also.
my lord.
To touch on whether maybe he may not know, he should have. He may not have known that law. But whether it is permissible to transfer an investigation.
No, in that case, my lord, he cannot, my lord, where the FIR was lodged, they cannot investigate because their jurisdiction is limited.
If they don't have the jurisdiction, no, there is one provision somewhere wherein it says that if an FIR is being brought to a police station and he has no jurisdiction, then in that case, what does 174 say? Okay.
No, that is police to inquiry and report on a suicide case. 174 is police to inquire and report on suicide case.
There is one provision where he is going to report it to the next police station. Where is that? Not provision. Finally, see 156(1). The jurisdiction of the police officer is this, which will be, again bring to 177. Any officer in charge of police station may, without the order of the magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have the power to inquire into or try under the provisions of chapter 12. 13. So the police station gets the jurisdiction from the court.
Yes.
And a court, therefore, you see, these courts, there's a jurisdiction being conferred with these courts, the criminal courts, those particularly stating that this court will look into these Panbaza police station, Penchbaza police station, so and so. And on the basis of that conferring of jurisdiction upon that court,
They can
the police station gets the jurisdiction under 156.
sort of the state jurisdiction.
Therefore, you see the judgment of Om Hemraji, it was an offense which was committed outside India. But which police station will have the jurisdiction? The Supreme Court said that once that person comes from there, because if it is an offense committed of an Indian outside India, then also the courts in India will have the jurisdiction in view of section 181 or 170 something. So under such circumstances, this person concerned, that was a woman in that case, she came over, filed a complaint before a court
In India.
in India. And on the basis thereof, jurisdiction is conferred upon that particular police station.
Where he lost the, but occurrence took place in different place. But
See, one,
how the investigation? my lord?
180,
181.
party. No, not. Yes, 188. Where an offense is committed outside India by a citizen of India, whether on high sea or else, or by a person not being a citizen on any ship or aircraft registered in India, he may be dealt with in respect of such offense as if it has been committed at any place within India at which he may be found.
That is 180.
So, therefore, if you see that judgment, Hemraji, 2001 or 2004, this was a case where there was an offense of 498A, which was committed outside India. She came over.
498, my lord, is a continuing
No,
effort.
maybe. No, she came over. She came back from that place outside India and lodged an FIR. And on the basis of that, the police, the court got the jurisdiction.
Here also, my lord, if your lordship go by 183, offense committed on a journey or a voyage. Here in this case, my lord, they are coming, they started their starting point in Polasbari and probably ending point in Silam, that Nongpu. So on the way, anything is happened, my lord. Any area, my lord, they cross, my lord, they have the jurisdiction. 183, my lord.
No. Therefore, it is not that Nongpu may not have the jurisdiction,
My lord.
which I told him on the earlier occasion also. Then look here, yes, the transfer was bad. But if otherwise Nongpu has the jurisdiction, being the place of occurrence, which this court cannot look under 226,
Right.
then obviously this court cannot touch on that aspect. I've said that to him. That I have already told him, and he was trying to justify with those judgments, which I am not impressed. But the thing is, if the entire thing was done on the basis of something which is absolutely illegal,
I got the
which was done
Yes.
there.
Yes, absolutely illegal. Yes.
You see, in one sentence, the judgment, the Madras High Court holds that the person who are the accused would not be at liberty to choose the pitch, would not be at liberty to choose the paying conditions and all in this manner. You see that judgment, the last one, the penultimate page. There's a quotation, what he says. See, there's a quotation last. Yes. Have you seen that?
Yes, interesting and trial cannot be converted by the companion and the accuser a friendly match. What friendly match? They are allowed to do so. The umpire who will choose the wicket.
Who would choose the wicket? Anyways, pursuant to the order passed by this court on 5/10/2023, Mr. T.J. Mohanto, the learned senior counsel, appearing on behalf of the Guwahati High Court, had apprised the name of the judicial magistrate concerned who had passed the order on 4/8/2014. Goodness. This order was passed on 4/8/2014
Afternoon.
on the very day.
Afternoon.
On the very day he left also.
Exactly afternoon. Yes. That day he left.
Huh?
That day he has got back.
Maybe. The state information is kept on the seal cover. And in the possession of the court officer of this court.
Well.
This the matter again on when can you file your second petition?
My lord, after 2 weeks. Till then, should come in motion.
This the matter again on, I'm not there for December, first week, second week. This is not parted.
Parted, my
Parted.
yes, my lord.
The word father hang is there probably. In costly stores is the father.
Matter again on 19th of December.
My lord.
For further consideration.
Regarding
Non-payment of contractual bill.
some amount that some amount the act is petitioner and the responsible one the agreement both development time and to hand over the beneficiary to respondent number 2. Yes.
Then?
And my lord, accordingly, my lord, as per that agreement, my lord, the land has been transferred. The land the petitioner company is the power of attorney holder of the land. So according to that power of attorney, my lord, the petitioner company executes LD in favor of the respondent number 1.
Who?
Respondent number 1, the house
Petitioner.
petitioner executed.
And sale deed.
Yes.
In favor of?
Respondent number 1.
Where is the sale deed?
My lord, sale deed is annexure number 3.
Annexure 3 is some Kogan Boru.
Yes, Kogan Boru and Hiren Boru and Govinda Boru are the original land owner. They executed the power of attorney in favor of the petitioner company. So petitioner company, my lord, executed the sale deed, my lord, as per that power of attorney.
Respond number 1.
What?
Then?
And my lord, develop the land. But as part of that, my lord, this is joint venture project to develop the land and construct
my lord, project completed and only handed over to the beneficiary. Beneficiary is enjoying and possessing that land as well as the other small other benefits. Now, my lord, out of 2 crore, 2 crore, 96 lakh 10,000 is the project cost, my lord. So already, my lord, only 16 lakh 81,750 rupees is balance. Now, my lord, during pendency of this case, already CISF, my lord, respondent to have filed their affidavit saying they have already paid the full amount to the respondent so far. And now, my lord, after that, the respondent one, my lord, filed their affidavit. My lord, from that affidavit, one thing is released, my lord, that the land which is transferred by the petitioner is originally belongs to the Bhudan board. To Bhudan board, my lord. And Bhudan board, my lord, transferred, my lord, given this land to these 3%, original owner, this Hogan Guru and my lord, this 3%, and NOC has been granted to them to mutate their name against that plus 7 bigas. Out of that 7 bigas, my lord, against that 7 bigas, my lord, this 3%, my lord, against whom this Bhudan board to donate it, they executed the power of attorney. And against that power of attorney, my lord, petitioner company, my lord, executed this LD for 4 bigas, 3 kata 10 kata. So in this petition, my lord, our claim is that for against that, my lord, project balance amount of 6 lakh 81,000.
What is the stand of the responsible?
They are saying that, my lord, since we did not do the mutation, so they did not grant the amount.
Lordship, there is a bar specific bar under Bhutan Act of 1965. Section 13, subsection 2A. The guarantee shall not entitle to transfer and sublet the land in any part thereof. So therefore, while we are trying to mutate our names, the circle officer did not mutate our names, stating that this land cannot be transferred. But the period is only for 2 years. Next section B says, section B says, the guarantee shall, section C. Section B says the guarantee shall not allow the land to be lie, follow or 2 consecutive years without reasonable cause. So there is when there is a specific part, therefore at the relevant time 2006 and 7, but sale permission was not required. Therefore the petitioner as a attorney holder, if I found it easy to transfer the land in favor of us, again we also found it easy to transfer in favor of respondent number 2. So there was no transfer in while transferring SSLD. But while mutating their names, that problem came up. Because circle officer said no to us. So we have only one thing, we are going to release that amount, provided they execute, carry out the remaining works, mutate our names, plus there is some development works left. There is some more development works left. So that part plus mutation part. If that is completed, we have no objection of paying that amount back. Paying that amount of 16 lakhs rupees or so. 16 lakhs, it may be plus minus. What he said may not be the correct exactly, but we have to pay some amount.
My lord, as per my instruction, in the project agreement, there are no clause regarding this. There's no condition of it. Only thing is that transfer the land and develop the land and to hand over the land. And regarding the remaining work, as per my instruction, my lord, that was already done as per their request. And already, my lord, CISF, the beneficiary has also filed an affidavit. In this affidavit, there are nothing, they did not mention anything regarding the, my lord, remaining work.
But did you get the money? When you
We got the
told
money.
it to the responsible.
We got the money. Now, problem we in that case, our because they have been writing letter, exhibit A, B,
Didn't you sign the sale deed
we sold.
executed by him to you?
Yes, we signed that sale deed. Only thing, after all, the department is also under the government undertaking, some state government undertaking, as well as central government
I'm
undertaking.
not on that, but the fact that you have received the money from him, you cannot, on that basis, you cannot say
Only
that.
thing, our stand is that we could not release only because of these two leftover jobs.
What are the leftover jobs?
So one, the mutation could not be completed.
Forget about the mutation. Mutation is nothing. That is another part of the thing for which you may file a suit for getting your right title interest or whatever may be. Mutation is
There is
done or not, that is a different aspect of the matter. Mutation has nothing to do.
But
But
development
the
part,
fact that in view of section 55 of the Transfer of Property Act,
Lordship.
here there is no question of withholding the sale consideration. The
Yes.
sale consideration has already been paid to him.
Paid.
So that has nothing to do.
That regarding the development part,
That has nothing. We are only concerned now with the development part.
yes, Lordship.
What is left?
We
You have
have
made a
specific-
big statement in your affidavit. Some development work is left. Finally come to paragraph number 12 of your affidavit.
That development part we have already stated in our exhibit A and B.
Which one?
Exhibit A,
What is the exhibit?
exhibit A, annexure A. With represent above, I have the honor
From
to
the
inform that the work
the
of
earth
filling
drilling
and
providing barbed wire fence has not been completed so far in spite of repeated last year. Even you have assured to complete the above remaining work of a joint verification. Now it is observed that you have submitted paper for receipt of 31% of execution of the pertinent to mention that the key of the main gate shall be taken and given to you by so for convenience. Now out of these 31 lakhs, you have paid 15 lakhs.
yes,
Remaining is 16 lakhs.
16.
What work thereafter has not been done?
There was supposed to be joint verification, but they did not turn up.
Huh?
There was supposed to be joint verification.
No. You say in your paragraph number 12 that
Lordship.
there were certain works he had to do.
Yes.
For which you did not
Yes.
pay him. Very well. 31 lakhs you hold it. Thereupon, you say that he did something for which you paid him 15 lakhs.
Yes.
What remains to be done?
That was need joint verification. He did not turn up. So there is no letter to say so that he has replied to our letter, exhibit A and B. He did not say so anything about that. He should have given a remainder affidavit. What he has done, what if he has done.
The B is mutation. Mutation has no business.
Only thing, my submission will be after all, court are state agencies. So
Huh?
court may direct the circle officer to immediate them, then it will be a problem.
Absolutely no. Why should I? That is not his
Without
prayer.
parties also.
That is your lookout. You are playing the, you are firing the gun from his shoulder to him.
Lordship.
Huh?
Lordship.
You can't do that. When you are paying the 16 lakhs, it's only a joint verification left. So what additional work is required to be done by him? You have not mentioned.
But only thing 16 lakhs, I can assure you to say whether it is 16 lakh plus or 16 lakh minus. In that case, he has to come.
You yourself have mentioned in your paragraph number 12.
Yes, Lordship.
Then how can you say that 16 lakh 84,000 you have kept it as balance? Then
We are concerned, my lord, respondent number 2, my lord, we have made the full and final payment of 2 crores 90 lakh. Now,
We have
my lord,
made-
the only issue that remains is my lord, mutation. Because
Yeah.
2008 itself, my lord, we made the
you
payment. my
have
lord.
not got your mutation, get hold of him.
Hello?
If you have not got your mutation, get hold of him. You will then get hold of him,
That is
and
what
then
is,
they will file a.
that is what is,
That is different.
All
You
this
see,
is civil.
mutation is in respect of another aspect. That is for the purpose of sale. Sale of
All-
the land.
It all needs civil dispute. It is more or less a civil.
That will be a civil dispute between three of you.
No, in the even the
Not
money
in
also,
respect
money
to this.
part is
No,
also.
whether mutation is in respect of what? A sale which has been made.
There was a specific part.
That there was a specific bar or not. You want to return the land to him?
No,
You want to return the land to him? You want to return the land to him?
No.
That, you can't have both the cake and say, no, I am not
Only-
going to pay for that.
Because in that case, if they stop by asking us that we don't need mutation,
That is
then we
there.
will not ask him.
These
We will
are
not
all
ask him.
your litigations you are imposing upon him. You are to pay this 16 lakh 84,000. The remaining, whatever you do it. You have a problem with regard to petition, file a petition or file the matter before the deputy commissioner or get the government involved, do it by yourself. That is a different thing.
the difficulty is, my lord, even they don't have the mutation in their name.
Obviously, they won't.
I cannot.
So get hold of them. Who sold it to you?
No, if he gets hold of me alone, I cannot. I'll have to catch hold of this man.
Get hold of him. Do
So
whatever
that is
you
what is.
But you are not willing to return the land.
Certainly not.
You are ready to pay him back the money if he returns the land.
Only thing that part can be deducted. The mutation part, whatever we spend it, that part may be deducted, so that he doesn't get 16 lakhs.
How do I know?
That is why it needs to be civil. There is a civil dispute.
Absolutely no, Mr. Bhagavati. Don't try
Lordship.
to make these type of
Lordship.
arguments.
What I believe that
That is a separate consideration.
my work
separate
will be
aspect of the
difficult for it.
matter. There's no
Now,
other way.
we are the worst sufferers because, my lord, we have paid the land.
I know that. Get hold of him. Pilot
Since 2008, my lord, nothing is happening, my lord. We have constructed our quarters there. But the problem is, my lord,
Mr. Counsel,
my lord,
kindly see your tail. Where is your tail?
it's in my affidavit, my lord.
Yes.
Elected 5.
Tail deed made by Housing Board in
Yes.
favor of
Yes, yes.
the President of India.
Yes.
Okay. Now kindly see here one provision.
Provision 3.
Kindly see paragraph 3.
My lord, I have paid.
And he gives an undertaking to you. He covenants to you. Yeah. Claimants assured that the purchaser CSF shall be entitled to duly mutate and record their names as the owners in the record of rights prepared under the Assam Land and Revenue Regulation. He says to you, get hold of him. And you say to him, I'll see his state
Yes, that's LD it is there.
will be there.
Yes. only thing. Lordship. That part can be deducted. That is why my submission will be
So except the mutation, there is nothing.
Yes, that part. Only thing, my problem, another problem is there. Since 2016, when they made me handed over the brief to me, all those numbers, all those I have to write. I cannot give any gap. Taking today. That when you're
No,
going to
no,
pay.
no. I'm not on that. On the basis of the materials, I'm not asking you. Is there anything else? There's nothing. Only see. What else is there? Only see in your affidavit at paragraph number 12.
That yes, that part is only thing. They
And
have
kept
told
the
me.
balance of 16 lakhs as balance and reminded the petition to complete the leftover development works to entitle him to remaining amount subject to matter of the writ petition.
If they
That
do not,
went so by transferring the land, that the devastator was aware of the fact that they
Your Honor, the Chinese case he took.
because you see at paragraph page 5, internal page 5 of your affidavit, the last 4 lines. Therefore, the answering respondent could not mutate his name and also could not mutate the name of the respondent number 2 as per the registered deed dated to enter due to the above legal part, and the petitioner is trying to absolve from his duties, and as such the petitioner is not entitled to. Meaning thereby it is only on because of this.
yes.
Then
Lordship, my submission again. If they say that they do not have anything left over, balance job is not there. If they are not, they are satisfied with the position. There is no reason to why I should be unsatisfied.
Huh?
Development works, what we have said now. If the beneficiary, respondent number 2 does not have any complaint, then I do not have any complaint as against that.
On that one, I have to get instruction for that.
no.
What are you saying, my lord?
See, there are 2 components. One is for the sale, which we have duly paid. For the development work, have you paid it to him?
Yes, it is complete. It is complete.
Full and final payment.
Payment has been made.
Yes,
Payment.
Was it an advance payment or on
One
completion?
one-time payment was made.
Was it an advance payment or on completion of the work the payment was made?
No, but they quoted the price of 2,000 for the entire work, for the land and the development work. The entire amount was paid to them at one go.
Before the development work was done?
That was
No, that is what it is.
the instruction I don't have. I'll take it. Tomorrow.
If that part they are happy,
Let us see your affidavit.
Page 21 of their affidavit. Is a money receipt is there.
It appears that the money was paid before the agreement was executed between.
Yes, sir.
Yes, one in, well, respondent number one and three. Because the closing agreement was executed on 6/9/2007. The money was paid on 27/8/2007.
When was the sale deed executed?
On 10/3/2008.
Huh?
10/3/2008.
10/3/2008 in your favor.
Yes.
And the payment was made prior to that on 27/8/2007.
Mine. The closing agreement between them was executed on 6/9/2007. Paragraph 4 of the report.
What was the development agreement?
Lord, annexure. Annexure, my lord, one page 19.
Date?
Page 19.
So as per you, there is no development work.
My lord, already.
Him also, there is no development work. And he does not say anything. He said that it is between both of you. He should be absolved.
My lord, kindly see page.
How?
It is the, my lord, communication, my lord. So in 2011, they raised the complaint that some work has been left out. Subsequently, my lord, that work has completed. And my lord, this communication has been sent to the respondent one by the petitioner.
Huh?
My
By
lord,
the petitioner. Yeah.
Yes.
Then
my lord, here, my lord, we here it.
Court has already gone.
That I have read it.
Only thing, as regards to that payment part, my problem is that 2020, I made them last. I do not know, some of them may survive, may not have survived. So I need some time so that I can write letter to them, because those persons are not known to me now. Because the MD is no more there in that case.
Is the Assam State Housing Cooperative Housing, Assam State Cooperative Housing Federation Limited is in existence or not?
It is existing.
That has not died.
It has not died. Persons.
I am not concerned with the persons. How are you concerned with the persons? You are appearing on behalf of a corporation.
Yes.
Then
All right. I'll write letter. I'll need.
you write letters. He wants to execute. He will file contempt. Let him do. That is his to come. Okay. Leho. The instant writ petition has been filed by the petitioner, claiming an amount of rupees 16,81,750, along with interest at the rate of 16% from the respondent number 1 against its balance due. The facts which is discernible from the pleadings is that a project agreement was entered into the facts as is discernible from the pleadings as well as the materials on record is that the petitioner, that the director of the petitioner, one, Mr. Suresh Kumar Kasliwal, was a power of attorney holder in respect of four bighas, 3 katha, 10 lechas of land covered by Dag number 549/1441 of KP Patta number 123/8/1007 of village Paukuti under Moza Beltola in the district of Kamrup. On the basis that the said director of the petitioner company was holding a power of attorney in respect to the said land in question, a project agreement was entered into by and between the petitioner and the respondent number 1, whereby the petitioner, who was the builder, agreed to transfer the right title of the project land infrastructure development in favor of the respondent number 1, free from all encumbrances, by executing a registered sale deed for the benefit of the respondent number 1. The total project cost was rupees 2 crores 96 lakhs 10,000. And from a perusal of the said project agreement, it reveals that the said payment was to be made in certain installments. pursuant to the said project agreement dated 6/9/2007, it further reveals that the respondent number one and again, in the meantime, even prior to the said project agreement entered into between the petitioner and the respondent number one, there were certain correspondence entered into by and between the respondent number one with the respondent number two for allocation of a plot oblique land for CISF residential complex. It reveals from the records that on 27/8/2007, the respondent number one received an amount of rupees 2,90,17,800 from the respondent number two as against the sale of 1.52 acres of land at Korusorai, Guwahati for CISF residential complex. It is on the basis of the said amount so received, the respondent number one entered into the project agreement with the petitioner. On the basis of the said agreement entered into between the petitioner and the respondent number one, a deed of sale was executed by the director of the petitioner in the capacity of being an attorney of Sri Khogen Boro, Sri Hiren Boro, and Sri Gobindo Boro. For sale of the plot of land এই উপরত আপনাদের লিখিত 4 বিঘা 3 কাঠা 10 লেখা আবার প্রায় টাকা hereinafter referred to as the land in question. For sale of the land in question. And by the registered deed of sale bearing deed number. What is the deed number? Two 2866/2007. Dated 22/10/2007. Subsequent thereto, the respondent number one, by the deed of sale being registered deed number 3934/2008, transferred the land in question in favor of the respondent number two. dated by the registered sale deed dated 6/3/2008. The dispute so arose. The dispute, however, arose on account of non-receipt of a part of the said consideration of rupees 16 lakhs
81,000.
81,750, which the respondent number one, had withheld from the total consideration so received from the respondent number two. But Mr. Counsel, I am dismissing your petition. The reason is this. It is on the basis of the project agreement.
Right.
The project agreement stated that you are to make the payment, you are to transfer them the deed. And on the basis of that project agreement you entered into, executed the sale deed. And if you have executed the sale deed, if he is not in a position, you are to file a civil suit. This court cannot give it because if it was not on the basis of the project agreement, but on something else other than that, it would have been different. But it was a cumulative thing which included the sale of the plot as well as doing whatever is necessary, and therefore he paid that amount.
My lord, yes, the project agreement is for, my lord, sale of the land as well as the development of the said land.
Whatever may be, you have done a part of it, and it was dependent upon the project agreement. Payment would be dependent upon certain formalities, and one of them was to execute the deed of sale.
Yes, sir.
Then
The other part left.
the entire title had not been conferred upon him. Wouldn't that be a case of a civil suit?
No, my lord, as per
If
the
that project agreement was for something else, just for development, and sale deed was for development,
yes, it is for
then the question would have been different.
Yes.
But it is one and the same.
yes, for the both.
So I'm dismissing. The record reveals that pursuant to the filing of the petitioner, thereupon, had represented before the respondent authority, the respondent number one, on various occasions, for release of the said amount of rupees 16,81,750, as could be seen from the annexures to the petition. However, from the records, as the respondent number one did not make the payment, in spite of having received the amount from the respondent number two, the instant petition was filed by the petitioner, seeking the relief as already above stated. This court had issued notice on 11/7/2016. Pursuant to the notice being issued, both the respondent number one as well as the respondent number two have filed their affidavit in oppositions. From a perusal of the affidavit in opposition filed by the respondent number one, it reveals that an amount of rupees 31,84,250 was withheld on account of the petitioner not performing the entire work as per the project agreement. It further reveals from the said affidavit that 15 lakhs was released pursuant to the completion, pursuant to certain completion of certain development agreement, and an amount of rupees 16 lakhs 84,250 was withheld. The reason why it has been withheld could be seen from paragraph number 13 of the petition of the affidavit in opposition filed by the respondent number 1, wherein it has been stated that the land which was conveyed by the petitioner in favor of the respondent number 1 by the deed of sale dated 22/866/2007, dated 22/10/2007, was a land belonging to the Assam State Budhan Board, which was settled to one Pabitra Kothari, and thereupon the said land, after the death of the said Pabitra Kothari, was transferred to Hogan Boro, Horen Boro, and Govinda Boro. It was the stand of the respondent number 1 that by virtue of that the petitioner, that the director of the petitioner very well knew about the said aspect of the matter, and by suppressing the fact, sold the land to the petitioner, respondent number 1. It has been further mentioned that in view of the selling of the land to the respondent number 1, which was an allotted land by the Assam State Budhan Board, the circle officer, the concerned circle officer, have neither mutated the land in the favor of the respondent number 1, nor mutated the land in favor of the respondent number 2, pursuant to the deed of sale dated bearing number 3934/2008, dated 6/3/2008, executed by the respondent number 1 in favor of the respondent number 2. It was further mentioned that it was the responsibility of the petitioner to get the land mutated in the name of the respondent number 1 as well as the respondent number 2 and the respondent number 1, so that the land subsequently could be mutated in the name of the respondent number 2. And the petitioner having failed to do so, the amount of rupees 60,84,250 was withheld. From a perusal of the said affidavit in opposition filed by the respondent number 1, it also reveals that there were various correspondence issued by the respondent number 1 to the petitioner, directing the petitioner to get the land mutated in favor of the respondent number 1. This court have also duly taken note of the affidavit in opposition filed by the respondent number 2, who categorically states in its affidavit that the respondent number 2 has no privity of contract between the petitioner and the respondent number 1. And the money in respect of the land was paid, sale of the land was paid to the respondent in respect to the sale of the land in question the respondent number 2 by the respondent number 1 was paid as far back as on 27/8/2007. And thereupon, on 6/3/2008, the sale deed was executed. But the respondent number 2 have not been also able to mutate the land in their name, and have also made various requests to the respondent number 1 to do the needful. I've heard the learned counsels for the parties and have also perused the materials on record. From the materials on record, it reveals that a project agreement was entered into by and between the petitioner and the respondent number 1, whereby the petitioner agreed to transfer the right title of the project land infrastructure development in favor of the respondent number 1. The terms of the said project agreement further reveal as to how the amount would be released subsequent to would be released. It further reveals from the said agreement that the legal right, title, and interest over the project land would be transferred to the respondent number 1, and the petitioner would also undertake development activities. The clauses 2, 3, 4, 5, 6 enumerates as to how the payment would be made by the respondent number 1 in favor of the petitioner. It further reveals that pursuant to the said agreement, this land was sold in favor of the respondent number 1 by the deed of sale bearing deed number 2866/2007, dated 22/10/2007. From a said deed of sale, it further transpired that it was the director as attorney holder of the Hogan Borough, Sri Gobindo Borough, and there were 3 persons. No?
Hogan Borough, Hiren Borough.
Huh?
Hogan Borough, Hiren Borough, and Gobindo Borough.
Hogan Borough, Sri Hiren Borough, and Gobindo Borough. Agreed. No, covenanted that the purchaser would be entitled, covenanted amongst others, that the purchaser would be entitled to apply for and obtain mutation of their names in the land records. taking into account that there are similar covenants of the respondent number 1 in favor of the respondent number 2, also in the said deed of sale, dated bearing deed number 34 dated 63934/2008, dated 6/3/2010. 8. The above would therefore would show that for being entitled of the amount, the petitioner is required to transfer the perfect title in favor of the respondent number 1. And the terms of the project agreement dated 6/9/2007 have not been duly complied with till date, as both the respondent number 1 as well as the respondent number 2 have not been able to get their mutation on account of some purported defect in the title. In that view of the matter, this court would not, in view of the above facts and circumstances, it is the opinion of this court that the exercise of jurisdiction under Article 2 to 6 of the Constitution cannot be made, is not required to be in the facts and circumstances. It is the opinion of this court that this is not a fit case where the exercise of jurisdiction under 2 to 6 ought to be made by issuing of a writ of mandamus directing the respondent number 1 to pay the remaining consideration of rupees 16 lakhs 81,750 to the petitioner along with interest. Accordingly, this court therefore dismisses the instant writ petition. Before parting with the record, this court, however, makes it clear that the respondent, that the petitioner, would be at liberty that the dismissal of the writ petition shall not prejudice the petitioner to do the needful for getting the mutation of the land and claim the amount, the remaining consideration along with interest from the respondent number 1. The above observation made in the instant writ petition shall not prejudice the petitioner in any such proceedings to initiate it for claiming the remaining balance consideration pursuant to the petition being duly done. Petition being duly effected in favor of the response.
I need some time to file affidavit. I have received the instruction notice on
Ah.
my lot 6/11. It was directed to file an affidavit on 9/11, my lord. It is so many particulars are there. Regarding ex grant,
Yes. What instructions you have received?
lordship, my lord, is a parawise comment I have received, my lord.
So on your own, you paid that 5 lakh.
My lord, that when my lord, that the disease wife, lordship, the mother of the petitioner, my lord, she got my lord, the appointment and she married to some other person. At the time of my lord, the marriage to some other person, my lord, the daughter of the petitioner was like, she was minor, lord. She was very minor. So my lord, she took with him, my lord, at the time of marriage. So she was not there, my lord, with the my lord, the parent.
So?
So whether my lord, the matters of the my lord, that the petitioner, my lord, he took my lord, her with her, my lord, whether they have been adopted him or her or not, my lord, that is not in here in the my lord, the instruction.
She is the daughter of Loknath Mr.
My lord,
Loknath.
my lord, at the time of she was very minor, lord. She was very minor. when the father was dead, my lord, she was, but as per the instruction, she was only 5 years or 5 months. Lord.
5 months,
My lord,
35 years. Today is,
now it's
when did you file this? 2017. 35 years will be 17 plus 17. 2017 minus 87.
in the meantime, she already married with her son.
What's your date of birth?
Date of birth is my lord, what?
In 2017, if you have filed it as 35 years, your date of birth will be 82. How can you be 82 when your father died in 81?
My lord, in fact, my lord, the date, my lord, order number 4, she has stated his date of death is my lord 30/11/81. The date of death.
No, it has been mentioned out here. The date of death is out 30/11/1981.
81. At that time, my lord, she was the 5 months. Yes.
How do you say so? If your affidavit age is 35, filed in the year 2017,
It's on the basis of certificate, my lord.
what certificate is?
That is,
Because your mother remarried. That is why I am saying.
Yes.
Your mother took a government job and remarried.
she remarried to other person.
Absolutely.
Yes.
You were with the mother.
I remained there, man. For some time,
Where?
I was
Where did you remain?
in my parents' place.
How? You were not born when he died.
I was of 5 months old, man. At that
How is it possible? Tell me. If your affidavit age is 35, or you were born after 5 months, that might be possible after the death of your father. What will be the date of age? 8? If it is 35 in 2007. So you deduct 17 from here, deduct 17 from there. So 83, 83, 182.
82. 35 is 17 is 82.
So 82 it has to be born. 18 years and 17 years, 35. Then you were not born when your father died.
I request
What? You were supposed to take how much money? I gave you some amount. How much?
that part of the right that
He was ready to give 250.
2 lakh.
250.
2 lakh. 50 was agreeable, but it but the for a top of poet, but okay. That sales is first, but
I said how much? 225.
okay. Because they editing and directed, but by the FCC by the but
Forget about them.
Yes.
225.
that 50 pilot 60 himself pilot agreed to that. That's what a performance that I want immediately I agreed for pay fund. Initially I paid to agree to pay with 1,50,000, my lord. After that, discussion made that I am able to pay the 2 lakh.
You have got the next of the kin heirs.
Yes.
Okay.
Is it
We direct the state to make the payment to him and recover the amount from him. Where is the next of the kin heir?
that is that pay 16.
Huh?
Pay 16. Rate protection.
16. Where is your next of kin certificate?
In fact, it's the next of the certificate issued to the my lord SOK of the party of my lord under this group fund. So that is my lord in pursuance of Rule 2A of Assam Public Service Preferential Appointment 1990.
So this is the certificate.
Yes.
So you admit to RTI, but later on, 2010, a communication was received from the respondent number 2 stating the name of the petitioner as the next of the kin of Martyr Loknath Soikia along with other beneficiaries. That since the amount of extra was paid to the respondent, the question of payment of another beneficiary at this stage does not arise. Now, who comes within the beneficiary list as per you?
The family of the Malot that
The first family will be the daughter.
daughter already been stayed with the mother, after marriage.
So what? Daughter is daughter. And this is being also admitted by the uncle. And this was written on 27/12/2016. And this communication is 27/5/11. And this document was sent by the Deputy Commissioner Nogao to the Joint Secretary for payment. NOK change. But in the meantime, as you have already made the payment, so you are not paying. Hello?
The payment already been made.
You will take it from them or you give it. That is she is entitled to. Will direct you to pay that 5 lakhs to her. Because you paid at your own accord. You see, that no next of kin certificate was issued in the name of Hogan Soikia by the registry as heirs of Loknath, as records have not been found. So and so, you invited the then government of Assam, so and so, the letter to Hogan Soikia, so and so, to attend the state meeting, and accordingly, rupees 5 lakh was allotted to him as an additional. Allotted. Can't help it. You invite somebody and as such you want to pay him, pay him. But entitlement is his.
But he's the only one of the brother.
No, brother can't be. Brother will be a second class A.
No one is there, my lord.
Then brother.
Then brother.
But the mother, son A was there.
So whether at that time, my lord, he was claimed this,
You released on 25/11. The Deputy Commissioner gave it out there on very well on 27/11, 27/12. Then look here, there is another one. What did you do? Isn't that your communication from your own affidavit? Your affidavit, kindly see this affidavit. Issued by the Joint Deputy Commissioner Nagaon to the Joint Secretary. With reference to the subject, please find enclosed herewith the list of NOKs of the martyrs of agitation falling under Nagaon whose ex gratia amount sanctioned momenta is not received by the NOK concerned for the reasons shown against their name. You are therefore requested to take necessary steps from your end. Who are those? Amongst others, Loknath Soikia Momi Bora, that's the petitioner, daughter, phone number, bank account number, NOK change. This is the observation of the Deputy Commissioner. So this is an admitted that she is the NOK and you pay it only to the NOK. You don't pay it to anybody else. And without the NOK certificate also you have given it to him. So you do whatever you feel like. 2 o'clock, I'll deliver the check. You can institute criminal case against. The instant writ petition has been filed by the petitioner seeking a direction upon the concerned respondent or court for payment of the ex gratia amount of rupees 5 lakh under the scheme of the under the scheme of the government of Assam for payment of ex gratia grant to the martyr's family. The facts involved, the facts as could be discerned from the materials on record reveals that the petitioner admittedly is the daughter of one late Loknath Soikia, who was killed by the police when he was participating in the Assam movement. On 30/11/1981. The petitioner, on coming to learn about the said ex gratia compensation scheme of the government of Assam, applied for the said grant of rupees 5 lakh. But the same was refused on the ground that the said amount had been already disbursed to the respondent number 4, who is the brother of late Loknath Mishra. Soikia. It is under such circumstances that the instant writ petition has been filed. to the said in the petitioner in the said petition. Have enclosed the certificate issued by the Additional District Magistrate Nogam dated 13/8/2017, issued in pursuance to Rule 2A of the Assam Public Service Preferential Appointment Rules 1999, certifying that her father was killed in connection with the participation in the Assam movement on the problem of foreigners, and that the petitioner was the daughter of late Loknath Saitya. Pursuant to the filing of the instant petition, the respondent number 4 had filed an affidavit in opposition wherein at paragraph number 6, he duly admitted that he had received the said amount of rupees 5 lakh and further that he never made any claim for the said amount. It was further mentioned by the respondent number 4 in his affidavit that the petitioner's mother got married with another person immediately after the demise of the brother of the respondent number 4, and the petitioner also went with her mother, who before the grant of the additional ex gratia amount of rupees 5 lakhs by the authority. It was also mentioned in the said affidavit that out of the amount of rupees 5 lakhs to receive in the month of December 2016, the respondent number 4 constructed a monument of the Martyr of the monument in memory of his brother, late Loknath Saitya, in the courtyard of the respondent's house, and spent an amount of rupees 2 lakhs, and further donated an amount of rupees 1,50,000 for the development of the Shiv Mandir of Brahmachari Satra on 1/2/2017. Further to that, an amount of rupees 10,000 was donated for development of a temple Namghar of Brahmachari Satra in the month of February 2017. The petitioner filed an affidavit in reply to the said affidavit in opposition, denying the contents of the said affidavit in opposition, and stating inter alia that the amount so paid and or donated is nothing but absurd and was without the knowledge of the petitioner. The record further reveals that an affidavit in opposition was filed by the respondent number 1 to the Deputy Secretary to the Government of Assam, implementation of Assam Accord Department. In the said affidavit in opposition, it was mentioned that a payment was made to the respondent number 4 on the basis of a report dated 25/11/2016 received from the respondent number 2. It was further mentioned that a payment was made to the respondent number 4 through RTGS, but later on 27/12/2016, a communication was received from the respondent number 2 stating the name of the petitioner as the next of the kin of late Loknath Soikia, along with other beneficiaries. It was the further stand that since the payment amount of gratia was already paid to the respondent number 4, the question of payment of another beneficiary at this stage does not arise. This court at this stage also finds it relevant to take note of the enclosures to the said affidavit filed by the respondent number 1. Annexure A of the said affidavit in opposition is a communication dated 25/11/2016 issued by the Deputy Commissioner Nagaon, whereby the list of the NOKs of the Martyrs of Assam falling under Nagaon district was enclosed. In the said communication, the list upon being perused reveals that against the martyr late Loknath Soikia, the name of the respondent number 4 was shown along with his phone numbers and along with his address, mobile number, and bank account details. Annexure B is a communication a month later that is dated 27/12/2016, issued by the same Deputy Commissioner, Nagaon, to the Joint Secretary to the Government of Assam, intimating the names of various next of kin of the martyrs of Assam agitation falling under Nagaon district whose ex gratia amount sanctioned memento has not been received by the next of kin concerned for the reasons shown against their names. The list enclosed upon being perused reveals that as regards late Loknath Soikia, the name of the petitioner was shown as the daughter along with her bank details, and in the remarks column it was shown that the next of kin changed. The remarks column, it was mentioned as inverted comma NOK changed. This court had taken up the matter on 12/10/2023. And on that date, this court sought for certain instructions from the District Commissioner of Nagaon as to under what basis the respondent number 4 was paid the ex gratia amount. This court also sought for the instructions as to whether the payment was made on the basis of a next of kin certificate produced by the respondent number 4. And if so, the said details may be mentioned in the affidavit to be filed by the District Commissioner Nagaon. This court further inquired with the District Commissioner of Nagaon as to what steps the said authority would take if the amount of ex gratia is paid to the wrong beneficiary. Today, when the matter has been taken up, Mr. J. Hendig, the junior government advocate, have placed before this court the instructions as sought for by the order dated 12/10/2023. From the said instructions, it reveals that late Loknath Saikya was killed in the Assam agitation 83 on 30/11/1981. It was further mentioned that the circle officer Samuguri Revenue Circle had reported that the wife of late Loknath Saikya, namely Premolata Saikya, was appointed in a government job and she got married and used to reside at her second matrimonial home. It was further mentioned that there was no communication between the said Premolata Saikya and other family members of late Loknath Saikya. Further to that, it was also stated that in order to pay tribute to the martyrs who sacrificed their life during the Assam movement, inverted comma, Shraddhanjali program, inverted comma close, was organized centrally by the implementation of the Assam Accord, Government of Assam on 10/12/2016 at Khanapara Veterinary College grounds to honor the families of the martyrs and extend financial assistance to them. Accordingly, the Principal Secretary, Government of Assam, the then Government of Assam Implementation of Assam Accord Department, issued a letter to the respondent number 4 to attend the said meeting, and accordingly, rupees 5 lakh was allotted to him as ex gratia, additional ex gratia grant to the martyr's family. It was also mentioned that no next of kin certificate was issued in the name of respondent number 4 by the district authority as heirs of late Loknath Saikya. The said instructions which were furnished during the course of the hearing is kept on record and marked with the letter X. From the above materials on record, it therefore transpires that the fact that the petitioner is the child is the next of kin of late Loknath Saikya is not in dispute. And this very aspect of the matter was also brought to the attention of the authorities concerned by the Deputy Commissioner Nagaon as far back as on 27/12/2016 This court had also inquired with the learned counsels appearing on behalf of the respondent department as to on what basis is the ex gratia grant is paid. It was submitted that an ex gratia grant is paid on the basis of the next of kin certificate. Or a certificate issued by the authorities concerned, certifying that the person concerned is the next of kin. What basis it has been? It has been submitted at the bar by the learned counsels appearing on behalf of the respondent department that the said ex gratia grants are being paid on the basis of either next of kin certificate issued by the deputy commissioner or by the or under the provisions of it is also given by the deputy commissioner. Na? This is what I am submitting. Or under the provisions of the by the office of the deputy commissioner. Now, this her certificate is also by the additional district magistrate.
Additional district magistrate.
So is the deputy commissioner additional district? DC means the ADC. Office of the deputy commissioner. From the facts narrated herein above, it reveals the respondent number 4 was paid the amount, ex gratia amount, by the respondent authorities on its own accord without the next of kin certificate being produced. It further reveals that the said amount was paid from the instructions as kept on record that the amount was disbursed to the respondent number 4 at the own volition of the respondent authorities. However, the entitlement in respect to the said amount was of the petitioner, who admittedly was the daughter of late Loknath Saikia. Under such circumstances, this court is of the opinion that the respondent authorities cannot deprive the petitioner of the grant of the amount of rupees 5 lakhs, grant of the ex gratia of the rupees 5 lakhs on account of their fault of disbursing the said amount to the respondent number 4. Accordingly, this court therefore directs the respondent number 1 and 2 to take appropriate steps so that the amount of rupees 5 lakhs is disbursed to the petitioner within a period of 60 days from the date of submission of a certified copy to the respondent number 1 and 2 to the Commissioner and Secretary, Government of Assam, Assam Accord Implementation Department, as well as the Deputy Commissioner, Nagaon. This court Before parting with the record, this court would not like to, or would make and like to make an would like to make an observation that taking into account that the respondent authorities have voluntarily paid disbursed the amount of rupees 5 lakhs to the respondent number 4. Not necessary, no?
Already because the 2016 the payment was prior to the payment of this the SBSA amount. Whether the petitioner was approved before the concerned authority, that is not in the clear in the rate petition. That I approve.
It is there very much.
Sir,
You
it
paid the
says-
amount in the month of December.
Then he filed an application, my lord, on the August 17th.
It is there. August 17 is there. But prior to that, that communication is very much there, na? Of the Deputy Commissioner, which we have enclosed as Annexure B. You have on your by yourself have given. That is on 27/12. Yeah.
Even
Obviously, she must have approached.
his my lord, old mother was mother looking better respond number 4. His
Huh?
mother was
What?
his mother was also there alive at that time.
Mother may not like. But she is the next of kin. A certificate has been issued by your people only. Before parting with the record, this court like before parting with the record, this court reserves before parting on direction within 60 days. Okay. Within 60 This court further grants the liberty to the respondent authorities no.
The amount has been recovered from the amount of respond number 4.
Huh?
Amount already been paid to the respond number 4. That to be
recovered. When to recover?
otherwise, my lord, they already been paid, my lord, so better the second time. they-
Now, yeah, that is high. I was waiting for the submit. Before parting with the record, this court finds it also relevant to take note of the submission of Mr. J. Hendrick, the learned counsel, the learned counsel appearing on behalf of the respondent, who submits that liberty may be given to the respondent authorities to recover the said amount from the respondent number 4. This court would not like to make any observations on the said aspect of the matter, and it shall be within the wisdom of the respondent authorities to take such steps as deem fit.
All right.
Yes, where is Mr. Kyle?
The main counsel is in court number 18 for a matter. So he will be in a while.
Here, let me dictate. Here, where is the Bombay High Court recent judgment? You got it?
The recent judgment should not.
I'll give it to you. Like, I'll put already.
My lord, I put a Karnataka High Court judgment almost on the similar fact where the reports were not produced.
Ah.
The reports were not
Record.
on the similar fact.
It will right. Wonderful. This is a judgment by Siemens Financial Service Limited versus the Deputy Commissioner of Income Tax.
Siemens Finance.
I've got it. I've taken it out. It was a judgment on 25th of August 2023 by Division Bench of the Bombay High Court on the same issue.
My lord, if I may point out, Siemens judgment is probably the post amendment judgment, post 2025.
No, 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 no. This is for 2015-16 assessment year. And therefore it was held that the jurisdiction has to be on the was not done properly and accordingly set aside on the basis that 140A proceedings can be initiated on the basis of being satisfied after taking the necessary sanction. And as the sanction was not taken from that authority but was taken from some other authority, it was set aside.
Right.
This is what you were also saying.
Yes, I had
You have given JM
three
financial.
judgments, one of Bombay, one of Delhi, and one of our own High Court.
You have given this one of Bombay.
I have Bombay, Delhi, and our own High Court.
Delhi.
Santiri Road. And my lord,
You have referred to something now?
yes, it's Karnataka High Court judgment. Now, this was a case where no reports were produced, no reports were found, my and kindly see para 6. Para 6, my lord.
Yes.
Mr. Arvind Learned Counsel appearing for the revenue fairly submitted that the original report file does not contain either the regions under section 148(2) or the approval granted by the chief CIT or CIT under section 151(1) of the Act. He placed the original file before us for our perusal. We also did not find these documents in the file. He has also on instructions submitted that even the report that was placed for consideration of the tribunal has been destroyed. Thus, in the absence of either the regions recorded by the AO or approval granted by the chief CIT or CIT, we made an attempt to find out from the other materials on record whether the approval under section 151 of the Act was obtained before issuing the notice under section 148. Then, my lord, kindly come to paragraph 8. I'm reading from the 9th line. The tribunal recorded such findings and further observed that the note sent to the CIT by the AO was not sanctioned /approved under section 151 of the Act. In the absence of the order granting approval by the CIT under section 151, or in the absence of any indication in the orders passed by the authorities below, including the order of the tribunal or the materials on record, that such approval was obtained, it would not be possible to assume that such approval under section 151 was obtained. The provisions contained in 151 are indubitably mandatory in nature, and since compliance thereof was either not made or could not be established by the revenue, in our opinion, the benefit will have to be given to the estate. Now, because of this, my lord, this notice was it was assessment was passed by.
Not that they are submitted to report, email report.
Huh? Where are the attachments of these?
Sir has given instruction to submit this to
What?
Actually, he's in
Does he
section different.
think that this court is to function in this manner, that he will just give me in piecemeal? Will record or display satisfaction. And you say that only one record is misplaced. What about the other record?
Lordship, the main counsel has in election different court. He will be in a while.
Okay, I said that the matter will be taken up at 2. Why was he not available?
He came here, but he has to call for different matters in court.
Very well. And Mr. Goenka, tell me, what about the other aspect of the matter where he is mentioning on merits? What is the other aspect?
My lord, the other aspect in the regions recorded, it has been alleged that profit on sale of shares have not been shown in my return. Now, my lord, last time in the last hearing, I have produced before your lordship in the writ petition the copies of my returns of income, that these the profit on sale of the shares which have been alleged.
I am perusing 5437.
5437.
Yes.
My lord, I will take your lordship to the regions recorded.
Where is it?
It is at annexure 9, page number 120.
120.
Page number 120 of the report.
Yes.
My lord, the regions recorded say that the assessee sold penny stock as identified by SEBI and investigation in Kolkata during financial year 10-11. Details given below. They have given the names of the script, amount, and the broker's name. Then, my lord, in the last paragraph it says, but as per the return filed for the assessment year 11-12, relating to the financial year 10-11, no income oblique loss in respect to sales of share have been disclosed. On the basis of information received from ITD penny stock, I have reason to believe that income has been escaped from assessment. Consequently, the case for the assessment year 11-12 is reopened under section 147. So, my lord, the only allegation is that I have not disclosed the profit on sale of these. That is it. Now, my lord, page 96, my lord. It starts from page 94, computation of total income.
Yes.
Page 96, my lord. Statement of long-term capital gain, transaction tax exempt under section 1030. Now, all these shares are disclosed here, my lord. And the quantum, the quantity or the sale price which they have disclosed is 37,43,187. And what is disclosed is 57,58,920. We have disclosed all the transactions. Now, my lord, when the
But this is exempted.
exempted,
Because at that point of time, there was no tax on this,
no tax, because
on the long-term
we
capital.
have paid security transaction tax on these transactions. Therefore, as per provisions of section 1038 of the income tax act, these are all exempted.
Okay. Now, if it is exempted, was there no purchase value of those?
There was purchase value.
But why have you mentioned it as 0?
No, zero is because, my lord, sometimes what happens, we purchase some shares, then we are given bonus shares. Of the bonus shares, there is no cost. The cost is
Are these all bonus shares?
bonus share. My lord. If you will see, my lord, at page 96.
Yes.
The purchase cost.
Hmm.
On the first two,
You have,
we have the
But-
rest are bonus share.
but purchase cost is there.
Purchase cost. is-
What about the others?
Others, they are bonus share.
Are these the bonus shares?
Bonus shares of the same company.
But where have you disclosed that this
We
is
have
a bonus share?
We have disclosed it
Yes.
in paragraph.
No. You have to disclose it out there in your return.
In our return, we have disclosed. That
Where?
is why this profit has come, my lord.
Yes. Where is the bonus share?
The bonus share we have explained in paragraph. Please. My lord, para 4A. It starts from para 4A.
Page?
Page 11
Of your petition?
of my.
No. In your return.
This is part of my return, the computation which I have shown.
No. Page 11 is your part of your petition.
Page 11 is part of my return.
I'm not there. On your return,
In
where
my-
have you mentioned that these are bonus shares?
My lord, this is the page 96.
Yes.
Is part of my computation of income.
Understood. But how do they know? How will the income tax authorities know that these are the bonus shares if you have not disclosed?
No, we have disclosed that these
Where?
are bonus shares in our ITR also. my
Yes, ITR, show me there.
Page number 100 and page number 115, my lord. Page number 15, last 57 lakh 58,923. This is
Wait.
copy of my return of income.
Page?
Page number 115.
15. Yes, I'm looking into page where?
Schedule E1, my
There.
lord.
Long-term capital gains from transactions on which. No. Where have you mentioned that these are bonus shares?
My lord, the profit has been worked out. The 57 lakh which I
That
have
is
worked.
what he is asking while issuing the notice. You are to explain it that. That's the only thing.
No. This is not the thing, my lord. They say that I have not, the only allegation is that I have not disclosed the profit. I have not disclosed the profit on sale of my share. I say that I have disclosed the entire profit on sale of my share. Some of these shares they have cost. Others are bonus share
Where have you mentioned that these are bonus shares?
in my computation of income.
Where?
In my statement, page 11, my lord.
Page 11 is your petition.
My lord, the provision means if I purchase shares of a company, then if I get bonus shares, then the bonus shares are added to the number of shares which have no cost. Here what I have done, the total number of shares, including the bonus share which I have got, have been disclosed here. In
Just for
my
example, Splash M, 3,500,
yes,
35,000. I'm just saying.
Splash M,
35,000.
okay, my lord. I'll
Now, this is here, you are saying that total amount sale price is 12,67,638. Okay.
Oh.
Net sale price is this. Purchased on 24/12/2009. What is the cost? Zero.
because these are bonus shares.
So if these are bonus shares,
Huh.
you have to reply to them.
I have taken the revenue which I had earned from these bonus shares in my return of income. My lord, unless I disclose these bonus shares in my return, how do I take the profit from the sale of these shares? I have taken the entire profit in my return of income. That is the only allegation, my lord. There is no allegation.
Now, why the different amount has been put out here? You see, Flash M, 35,000, date of sale is date of sale is 22/3/2011. Here the sale price has been put at 12 lakh 29,000, 12 lakh 67,638. Here the same thing. The amount has been put at 2 lakhs 14,465.
Which item, my lord?
If we read 96 with page 120,
96, 100 and
on one hand, 96 is your return
96 is my return.
and 120 is the reasons recorded. Now, kindly see in respect to serial number 3. Splash.
The reasons recorded, the entire information is wrong, my lord. This information is not correct.
How can this court decide?
Huh?
How can this court decide? The reasons are right or wrong?
No, my lord. My submission is that they say that we have not disclosed the profit on sale of these shares.
No, you have not disclosed what? The no income oblique loss in respect to the sale of shares have been disclosed.
Yes.
You say that you have shown the profit of 60 lakh.
They say we have not disclosed 37 lakh. The total of this is 37 lakh. We say we have disclosed 57 lakh. So the information which is mentioned here is not correct, my lord. That is why the Honorable Division Bench, my lord, when the matter came up before them, I will produce the order dated 14/9, which is there on record, my lord. They have said, my lord, we find on a prima facie basis that the reasons disclosed in the notice under section 148 are based on incorrect premise.
That is prima facie.
Huh.
We are not on it. Now we are not
That
on the basis
is
of
no
prima.
income loss in respect of sale of shares has been disclosed in the return filed in the assessment year 11-12.
That is on a prima facie basis. That is a division
Yes.
bench. I am not aware. Interim orders are being passed on the basis thereof. But the fact is, the fact that you have these are bonus shares.
Yes.
How will they know if you have not disclosed in your return?
They will know when I sell my entire holding, my lord. They will only know well because since it has got no cost. When there is no cost of bonus shares, obviously, since no cost is there, it cannot be shown as investment.
Yes.
It is only the sale price when I get. The sale price I fully disclose in my return of income.
Absolutely. No, that is okay. But how
And-
will they know that it is the bonus shares? That you have only sold the bonus shares. How will they know? That is why they are asking for you to show cause.
No, my lord. This is the only reason that has been recorded. Kindly see the reason again.
I've seen it in my on the basis of the information received from the yet no income oblique loss in respect to sale of shares have been disclosed.
There is no allegation that I have not disclosed the bonus share. This is not the allegation.
No, no. You are saying it needs to be the bonus shares.
Yes, my lord.
That is your stand.
That is my.
They say that you have not disclosed the purchase price in respect to those shares. And as such, the income oblique loss has not been in respect to the sale of shares have not been disclosed.
My lord, the purchase price in respect of the bonus share will be nil.
Understood, but how do they know? How will they know that these are bonus shares?
I have disclosed in my return of income.
Where?
They have not verified.
That is the only thing.
My lord, the disclosure of bonus share, there is no provision anywhere to disclose in my return of income. There is no column.
Yeah, you can very well reply to their notice and give them and saying that these are your bonus shares. That's all. It's only a issuance of a notice
my
under
lord,
148
My lord,
as to why the proceedings should not be reassessed. That's all. They will then consider and then decide. That is what it is. You are saying this, but you don't satisfy this court on 151 too, without satisfying that. The
My lord.
second, you were not there. That is why I was asking Mr. Goenka as to on the merits. But first of all, how do you satisfy 150? And your communication only shows that as regards the petitioner of this case, you don't have the records for 1112. But what about the others? You have. Then why? What is this hide and seek by the income tax department? Then you have reached. And why are you not enclosed giving me the copies of these attachments?
That has been given out.
No,
Yes, Lord.
no, these attachments are not here.
These attachment, Lordship, with regard, these are the.
There are 4 attachments.
Yes, Lordship. Yes.
Where are those 4 attachments?
Lordship, earlier I
You forwarded to him. No.
No,
These are
given. Earlier, Lordship.
Mr. Counsel,
This is the.
Mr. Kyle, these there are 4 attachments.
Yes,
Which are the 4 attachments? Show me.
Yes, Lordship. This is with regard to present.
What is this?
Lordship, this is a reason for issuing notice under section 140.
Understood. But why this was never a part of your document at page 120? These things which have been mentioned.
So that approval was taken from the JCTI.
Who has written this? This handwriting is done by whom?
By the officer.
When?
It was Lordship.
Huh?
It is 2000.
No, they. Huh?
30th of March 2016.
And if this is so, and this is the reason for issuing the notice, why this was not a part of that communication at page 120, which has been enclosed by the petitioner? This must have been done subsequently, or this must not have been a part of the record now after the filing of the petition. You have made it.
Presumption can be strong.
Huh?
Because record is not there.
Yeah.
So I cannot deny that.
No, these things can't be there. You are saying that the online request for approval from the JCIT, Jorhat, was submitted. As approval is granted, notice under 148 is generated in the system as issued.
Yes.
But who has written this? Whose signature is it? And why this was not a part of page 120 of the petition?
That only notice was given to this was a part of the record. The relevant.
Where is the record?
Yes, Lord.
And why the records? You don't have the records of one of the petitioner. What about the other records? Kindly see today's communication. Have you read it?
I gone through the mail.
What does it say?
Yes,
And apparently the record of Girish Kumar Agarwal for AY 2011-12 have got misplaced during the process, and effort to trace out the same have not yielded fruit.
Not mention about other three cases.
What about the others? Why the others have not been brought? We'll ask the income tax officer, Ward 1 Jorhat, to be personally present tomorrow.
He's on medical leave.
Tomorrow?
A week, because his wife is operated somewhere in Delhi.
Then anybody hire?
Probably he's the appropriate person to.
No, who is hired to this? To be personally present with the records?
From in Jorhat, IPO is the AFO. Probably at this stage. 45, I'll confirm and I'll come back tomorrow.
No. You confirm now and come back today.
Sure.
We want the date. And this week, Saturday, this matter this son can't go on. Shown as Martyr. Huh?
Monday.
Saturday, I have very less work.
No, Lord, if I understand.
I have Saturday very less work. And Saturday is a working day.
Yes,
No, Saturday is a working day.
Yes, Lord.
I've asked them no more matters except this income tax matter. Saturday.
I talked to the IPO. He's on medical leave because he's.
So get hold of anybody else who is more competent. Why these records are not there? And they are taking their own pleasure. This IPO. Saturday, 10:30, 10:15. Get hold of the record, 10:50.
I'll ask.
This court is going to deliver the judgment on Saturday. You get or no? That is your lookout.
I'll communicate today itself.
You communicate whatever.
My lord, just to take the in my submission, my details, I raised two issues. One was regarding the since recorded. The only allegation is that I have not disclosed the profit sale of share. There is no other allegation. Now, whenever there is a challenge to notice of the section 148, the reasons are to be read as those are recorded. I will submit for your lordship a number of judicial pronouncements, including of our own act. And
Give me only one. Why do you need so many?
yes,
One will do.
so that is one aspect.
Hmm.
The second aspect was violation of provisions of section 151.
That I know.
That is there, my lord.
That is the only thing which I am taking.
And not only my lord, they say that they have taken approval from the commissioner. I have made my.
They have taken the approval from the JCI.
Yes.
That
No,
is
in
what
the
they are
notice-
saying.
In the notice, they say it is from the commissioner.
No.
And whatever they say, my lord, the onus is on them to prove. They have to produce the record.
Hmm.
There cannot be any assumption on this ground because this goes to the very root of the jurisdiction. So, my lord, these were the two basic preliminary objections which I had. If your lordship want me to make my submission.
And this record, this instruction was given on 410. And what is your up-to-date instruction? What is the 410?
Yes, sir.
Then thereafter I passed the order on 510. What is it?
But same situation is same.
You have not cared to take it out. Even after this.
Lordship, on the very day I communicated to the officer, and thereafter Lordship.
Officers, they don't care. They are not bothered. We'll dispose it off on the basis of no record being produced.
On Saturday, I'll ask the officer to.
Hey, you get hold of the officer or not produce the record. Any person. I don't need the officer. What am I going to do? I'm giving you a final chance on Saturday. And what is that the judgment which you are referring to? And under 148?
My lord, I will have to file a compilation.
Why? I don't require compilation. Only one judgment. Why do I require compilation? For so many?
My lord, I'll My lord, under section 148(2), my lord, the recording of region is mandated because the regions are justiciable. And my lord,
But are the reasons to be read like a statute?
not like a statute. What has been held, my lord?
What has been held?
When there is a challenge to notice under section 148, the whole basis is the reasons recorded. Now, the court, including our court, have held that in the case of a challenge to notice under section 148, the reasons are to be read as those are recorded.
Hmm.
There cannot be any addition, subtraction, modification, any change. No inference can be drawn from the record so as to give a different meaning to those notes. The reasons those have been recorded. And I am placing the land there are two judgments from our own High Court, my lord.
Hmm.
One is Assam Company Limited, 270. All are in my compilation. If your lordship want, I can give you a copy.
Assam company is the Guwahati judgment?
Guwahati, 275. Then another Guwahati High Court judgment is Guwahati Metropolitan Development Authority.
Where does it say
And
that it
My
has,
lord,
it has to be read without adding, subtracting anything?
compilation page 38, my lord, para 45. Some company. The same view was expressed in Associated Stone Industries. The Bombay High Court on the same issue in Hindustan Lever Limited versus
No, this is
RB Watt.
no, Mr.
held that the
Mr. Goenka. This
My
is
lord.
the same thing. Any order passed by authority has to be read on the basis of what the order says. Nothing more you can add by way of an addition, by affidavit, or by submission. That's the law. That's you don't require the judgment. It starts from the 1952 Supreme Court. Yes. Now, then
my lord, Hindustan Lever, Bombay High Court is compilation page 29, my lord. Para 20. Para 20, my lord. The reasons recorded by the AO nowhere state that there was a failure on the part of the assessment. So fully and truly all material facts necessary for the assessment. It is needless to mention that the reasons are required to be read as they were recorded by the assessing officer. No substitution, no deletion is permissible. No addition can be made to the regions. No inference can be allowed to be drawn based on reasons not recorded. It is for the AO to disclose and open its mind through
so
reasons
on the basis
recorded.
of this, you therefore submit that if they had to record the reasons, they should have stated that they have not shown the purchase price. And as such, whatever they have mentioned as the sale price, there was some, the profit and loss has not been properly shown. So you mean to say that the reason should have contained these things. Without that, you can't add or subtract.
My lord, the regions must have the live link between the regions as they are recorded and the escapement of my income. That
And it couldn't have been vague. Couldn't have been vague.
It could have, it couldn't have been. Then, my lord, GMDA's case, our own High Court, compilation page 89, my lord, paragraph 13. Paragraph 13, my lord. Last line I am reading. It is also important that the relevant material must appear from the order whereby the assessing officer has decided to proceed with the reassessment. And the satisfaction of the officer cannot be supplemented by the revenue through subsequent explanation public affidavit.
Okay.
Then, my lord, a number of other judgments are there with, given in my comparison.
Matter has been heard. Matter has been heard. The hearing, the hearing of the matter has been completed. Be that as it may, this court grants a final opportunity to the Income Tax Department to produce the records in respect to the instant matter as directed. Record in respect to the instant matter on 18/11/2023.
My lord,
Failure to produce the record, this court shall dispose of the petition on the basis of the available material. List the matter on transfer as the first item. Take it on Martyr. You just see that Siemens judgment. I think that Siemens judgment is directly applicable
Right.
in your case. That specified authority the Bombay High Court Division Bench judgment had given dealt with many aspects. One was change of opinion, all, but here he has dealt with specified authority,
Right.
and there one. So how much is the land? 2 kata 13 letter. Then
Yes, my lord. Lord, you would see my prayer. Lord, you would see my prayer. And para submission made.
what is the procedure?
Lord, Lord, you would see control.
No, that is not there. Are you going to say about the procedure now after the acquisition proceedings have gone on?
My lord will kindly.
They will demarcate and find out if any land is there, and you are to give away that portion of the land.
My lord,
What is that? What procedure is required?
my lord, kindly have a look at the act first.
I've seen that. You
No,
have
no,
seen it. 26(2).
But there is other provision that I want to put before you.
Yes, yes.
My lord will see section 23.
Yes.
Subsection 1. Key. All land forming part of a highway is based in the central government or is not already based in the central, but have been acquired for
You're
the
reading
purpose-
20?
Section 23 of the Control of National Highways, Land and Traffic Act.
Yes. All lands forming part of the with best in the system.
Not already based, but have been acquired for the purpose of this act and other sectors deemed to be the property of the central government as owner thereof. Subsection 2, my lord. The highway administration shall cause to be maintained a record in the prescribed manner in which the particulars of the land relating to the highways of which central government is the owner shall be entered, and entries of the particulars of such land in any record maintained for such purpose before such lands made in the first state record, and according to the central government shall be deemed to be the owner of land regarding which the entries have been made in such record maintained before the commencement. So, my lord, it is the duty of the highway authority to maintain that. And now lordship comes 26. Lord, because though, Lord, even assuming, Lord, we are Lord, having possession of more land, but in what manner, how, Lord, that would be taken, Lord, lordship has seen the manner in which the
the verification was done by the officer of the circle. Therefore, 26(2) comes. And in their affidavit also, they say us as encroacher. So it's basically, and they have put a post also there. So we'll get a right to object to also and my information similar kind of proceedings has been carried out by the National Highway Authorities. Section 3 I get an opportunity.
What do you say about 7?
7 is an exceptional which cannot come in
Why not?
these circumstances.
Why? Construction or creation, whether temporary or permanent.
Yes, if it is in a it's being continuing or in the process of being constructed. My boundary has been constructed and sheds have been constructed long back, and they had posted a post, and from the boundary itself, we had constructed.
No, it's not in the process. Doesn't say about the process. If such unauthorized occupation is in the nature of construction or creation, whether temporary or permanent, or trespass or other unauthorized occupation which can be removed easily without use of machines or other devices. Why not? These two will apply where you have some right out there. But here, admittedly, 2 katha 13 letters of land, you yourself by your own document state that you are in possession of 2 bighas.
I have also asked for that if you have to do anything, assuming what procedure and how they will assuming I am in an encroacher, which in their affidavit says, if I am an encroacher, they have to follow a due process of law. And what is
the
asking
procedure? 26(7) it doesn't require procedure.
7 will not come into play,
Why not?
My lord will see.
Notwithstanding anything contained in the section,
Yes,
the highway administration or the officer authorized by such a in this behalf shall have the power without issuing any notice under this section to remove unauthorized occupation on the highway land if such unauthorized occupation is in the nature of A, not necessary, B and C. And in removing such occupation, the highway administration or such officer may take assistance of the police if necessary to remove such occupation by use of reasonable force necessary for such removal.
But that would be in the nature, which can be exercised without, will kindly see.
Without use of any machine
or other device.
They won't use
My lord,
it.
my boundary wall has to be demolished, my
Oh,
shed has to
Why
be
do you need
demolished.
a machine for that? They can humanly do it.
My lord, if two provisions are there, my lord, one has to be read, my lord, which is beneficial to me, my lord.
Absolutely no. When it is an admitted fact that you are
My
in
lord,
occupation of their
My lord,
land,
it has to be determined.
there's no required
With due
determination.
respect, my lord, with due respect, my lord, it has to be determined which portion
Determined
they
for
will take.
what? Determined for what?
Determined in the manner in which, my lord, they will take which part, my lord, they will take and how.
This is
And who
what
will
they are
determine this,
going
my
to
lord?
take. Which part is the part which will be there? Therefore, this court have asked you for this demarcation and all.
Therefore, my lord, this demarcation, my lord, is not valid in law, my lord. My lord, because I have stated, my lord, it's
No,
not been done in my
We will
position.
exercise now 26(7). Yes, what do you say?
Lord, because 23(2), my lord,
26(2) may not be there. 26(7).
Yes, Lord, it's 26(7). Here already matter has been, this matter is before Lord is determined. This matter is determined before this honorable court by this as per order of this honorable court. Now suppose, for assuming this one, if it is changed also, what will be purpose? Same will be. You cannot change it because it is on record. This is you before
Well,
Lord.
he himself admits on record that he is in occupation of 2 acres of land.
Moreover, that is on record, my lord.
You
Now they
can
cannot change
admit
it.
be in occupation of 1 acre 90.
Yes.
In 1 acre
4
4
katha,
katha,
7 lesser.
7 acres.
Lord, that's why this provision has been made for encroachers also, my lord, assuming. Lord, therefore, 2 has to come, my lord. And in view of,
No,
my lord,
not
23(2), my lord,
No.
because
He-
they are the, my lord, custodian of the
Yes.
record.
This would
From
have
their
been,
records, it has to come, not from the office of the circle officer, my
my
lord.
lord, it would have been not before lordship. This entire matter has been heard by your lordship. Lordship due the direction, demarcation is made, everything has been now returned. Suppose if we assuming this one, if we send it, how it will be improving only? It cannot be improved. He cannot say, now your lordship, he himself accept portion, his admission. Now can it be changed, my lord? By changing, at the max, your lordship pass the notice, we will pass the notice. Notice will say, same will say.
No, my lord, I am on a different
No.
point, my lord.
That is why, Mr. People, lordship, this should be finalized, my lord, as per 7, my lord.
And who has done this acquisition? You.
Acquisition by Mr. Kala.
And you have not handed over that portion of land to the highway.
Because of this pendency of this case.
That was done in 2006, 7, 8. I have got compensation in 2012, my lord.
Maybe. But then also, you have not handed over the possession. So it is for you to demarcate and take out that land and give it to him. Take out 7 letters of land from him, 13 letters. Hey, compensation, there is nothing. And he himself admits in his affidavit.
Now,
The entire materials on record. I would have otherwise said something else.
Yes.
But his materials on record categorically admits that,
Everything.
look here, I have given 2 kathas of land. Without taking notice that actually he should have given 2 kathas, 13 letters of land.
let them.
Lord,
Because just take 24.
that is, my lord, that was, we were given impression, lord. Lord, we are in possession of 2 bighas.
Listen,
Yes.
it should have been in possession of 2
2
bighas.
bighas, yes.
The only thing is,
and
this
my-
court can look into it, is that so less that if this can be taken away from you, those portion of the land, and they must have, prior to the acquisition, you must have marked out the land.
Should have been.
100%.
Got
This has to be marked out. Without marking out, it couldn't have happened.
Got
Because if this land has been taken for highway, it will be a straight land. So his adjacent land, it can't be, after this, there will be a broken off,
Lot.
and then this will come inside and then they will go outside. And what about this serious allegation against you?
Lordship, according to my telephonic instructions, Lordship, this signature is put by that person. The signature is put by that person, Lordship.
Why haven't you filed an FIR? This is a very
And
serious
regarding
thing
that,
which you are
Lordship,
making allegation. Why haven't you filed an
I'll
FIR?
file an FIR. That's it. I'll file an FIR.
Lordship, kindly see.
Why you are now before this court? I have suggested you are going to.
No,
Who has asked you?
I'm not
Don't
on
expect
that
that
issue.
this court is.
No.
I'm only asking why haven't you? It's a very serious thing. Somebody putting your signature. You are making certain serious allegations.
And may I place one thing, Lordship?
The most serious allegation is a signature being put by you in some other place. These officials have copied.
Yes.
The very serious allegation.
Yes.
Yes, Lordship. And your Lordship, kindly see, our affidavit is filed on 16/10. They have replied on 25/11. By that time, Lordship, might have they have want to develop the facts.
But why haven't
By
you
that
filed
way-
your affidavit in the meantime? FIR. Why?
And during this period,
That
they have
is
not
the
lodged any
allegation.
complaint also.
On the very day. No, okay. This happened on 13th or 14th.
Yes,
On 50, the next day, very next day, you went out there. Did you raise that objection in your thing that my signature was not there or doing something to that effect?
it was done on 39,
Huh?
309, September month, the inspection.
Inspection was done on
Your Lordship, kindly come to page
39.
Yes.
39. And then you said that you went on the next date or something. Where is that? Yes.
And they have not lodged any
You
complaint with
went
this
on
also
39 to
before
the
the
circle
authority.
officer demarcation. This is for your reference. My land is so and so. We have purchased 1 bigha, 2 kathas of land in so and so. We have been issued land mutation certificate after demarcation of land, leaving 2 kathas of land, and hence we constructed a factory and boundary wall, leaving 2 kathas of land and keeping 2 bighas. So we were then of 2 kathas and remaining 2 bighas is under our possession. So we would like you to kindly demarcate. Then how can you be in possession of 2 bighas of land? Should have been 1 bigha, 4 kathas.
So that we are not. That we are saying. Lord, what I am.
No, you are not saying. When this court caught the hold of you yesterday, then you are saying
That's
that
true.
it is
Because,
0.072 hectares equivalent to 53 liters.
Lord,
Yes.
the Lordship kindly consider the day they filed an affidavit, my Lord. The Lordship was had asked me to take up the matter at 2. Then I will take instruction over phone. And then at that point of time itself, I made a submission before your Lordship that this signature is not ours. Lodging an FIR or not, Lord, this is a different thing, Lord. But on that very day, Lord, I made this submission. before
What
your
happened thereafter? You say in your affidavit,
Let-
kindly see. No, you kindly see
No, your
in,
Lordship would-
in your affidavit
Yes,
which
yes.
you have filed.
Hmm.
It's a very serious allegation
Yes,
you have
yes,
made.
Lord, I stand by this allegation
No,
till
no.
now.
In this context, it is submitted that though the petitioner's representatives were present on the site for soil joint verification of the land in question on 30/9/2023, they were not consulted by the lot mandal, and their request to find out the measurement from the middle of the national highway to the boundary of the area was not considered. Even the representatives were requested to the lot mandal to measure the land occupied by the petitioner as well as the distance between the pillar fixed by the National Highway Authority and the edge of the National Highway, but nothing was done. The lot mandal with the office of the air abruptly concluded the joint verification and did not provide any copy of the report of the joint verification to the petitioner side, nor they asked anyone of them to sign the said report. In fact, the circle officer whose signature appears in the joint verification did not visit the site.
Lordship.
He was there.
No, Lordship. He was not there. From our affidavit also, Lordship, it doesn't reflect that he was there. He was not there. He sent the officials of the Lat Mandal as because the measurement is done by the Lat Mandal. The Lat Mandal done the measurement, Lordship. Therefore, submitted a report. On the basis of that report, Lordship, this report was, and in the, if your Lordship comes to the the attendance register, his signature is not there. It is apparent. We are placing the whole thing before your Lordship.
Then why did the circle officer sign it?
No, Lordship, this report, It is a report prepared by the circle of on the basis of the report submitted by the Lat Mandal.
No. Why
Yes.
did the circle officer sign it?
Yes, Lord. Chief Circle Officer, National Highway Authority, as well as the Lat.
They were present. But the circle officer, you were not present.
No, Lord. In this report, the signature of the factory manager is also not there. As because this report is prepared on the basis of the report submitted by the Lat Mandal. This report.
But then your report should have been different.
The Lat Mandal report.
Then
It
why
was
did
sent
the
to
Lat
me.
Mandal sign out here? Why did the NHA officials
No,
have signed
the
it?
Lat Mandal's report, it is in Assamese, Lord, in vernacular. On the basis of that report, this report was prepared. The
Understood.
content.
Understood.
Lordship.
Once the Lat Mandal makes the report,
Lordship.
it is placed before the circle officer.
Lordship.
The circle officer, on the basis of the Lat Mandal's report, shall prepare a report and place it before this court. But he was never present. He was not a part of the joint
Initially, he
verification.
went there, but all along he was not there. It was told.
Now you are saying he was not there at all.
Yes, Lordship. That was told to me that he
Then
was.
he was not there at all.
Lordship.
Then why did he put his signature in this joint verification report?
No, Lordship. It's not the attendance rate. This is the attendance rate. Next page. Next page, Lord. This is the attendance sheet. Attendance sheet, your Lordship, kindly see the signature of the Lat Mandal, the signature of the site engineer of the National Highway Authority, and the factory manager. And now he is also disputing that the signature of the factory manager is not this. It was forced. That was his allegation. Regarding, and if it is done something, if something done is wrong by them, what they have done from 39/2023 to till date without lodging any complaint before the TC or ADC, they have not lodged any complaint. After filing of this affidavit in opposition, they have come out with this story in their reply. They never filed any complaint before the concerned authority. Had it been filed, they would have surely again done the verification. It was never been done. In our affidavit, Lordship, nowhere we have stated. Even if your Lordship direct that in presence of the Deputy Commissioner, it should be done today also, Lordship. That can be done, Lord. That they should be present.
And who is the highway administration officer authorized?
Yes, site engineer. Site engineer is available. Yeah. This is site engineer works under.
He's the person authorized?
Yes, site engineer, only he is engineer who is visiting in site and all that. Because under, he's working under project director.
Has he been authorized?
Yes.
As per the traffic act?
But notices were issued from our side to be present. Accordingly, he was there.
Site engineer, but generally, this site engineer is available only.
And the control of an act to provide for control of land within the national highway, right of way, and traffic moving on the national highway, and also for removal of unauthorized occupation. So there you have an authorized officer.
Yes. Where, my lord, where
is defined under F, my lord.
that is
Highway administration.
it is schedule is there, my lord. When we send this notice under this provision, there is signature of highway administrator or officer authorized. Here, schedule your lordship will get in page 1 page. In I think same.
Where is the definition of authorized officer?
F, authorized officer is not there, but the administrator has been. Your lordship would see section 23, where the highway administration.
Highway administration means highway administration established under Section 8.
My lord.
The central government shall by notification the officer established for the purpose of the act of body or corporate. So this is it. The central government may establish one or more highway administration for highway administration for the state of India, subject to that highway administration shall exercise the power conferred upon it under its act in such manner as to be prescribed. Power and function the highway administration shall exercise discharge throughout the specified under this act, subject to or limitation as may be.
23-2, my lord, he has been authorized to maintain the record. 23, the highway administrator.
What is this record business?
Alert.
No, why? What is this record business? The record is already there. They have
Alert.
filed it.
Alert. No, what I am submitting before your lordship is this. Lord, it is not the, Lord, since it's a National Highway Authorities land, it's not the, Lord, jurisdiction of the circle officer to maintain whether this belongs to, Lord, somebody else or not, or it's a private land. Under subsection 2 of section 23, Lord, they have to maintain a record on the basis of which
Their record is shows, from their records, it shows that 0.72.
That is not that record, my lord. That is only notification, and that is as regard, my lord, because your lordship would see under subsection 3, if there is difference or any discrepancies, then one has a right to challenge that also, my lord. 23.3. That record, how much acquired, what is the distance, Lord, these are all. And that's how, Lord, perhaps the pillars.
You've done that.
No, I have not done that.
Don't make those submissions.
No, Lord, I am making this submission only for the purpose of 26.2.
26.2 is not there.
Read with subsection 2 of 23. And what I am asking before your lordship
The
only a due
officer
process.
authorized by such administration. That means this person has to be authorized by the highway administration.
Alert.
This person has to be authorized by the highway administration. The site officer, has it been authorized by the highway administration?
This to be seen, my lord. Here, the question was here. This, we have not sent notice under this certainly, because
It's okay. You can still do it. But
Yes.
has this person been authorized by the highway administration? That is what I am asking.
that site engineer. Site engineer.
Because highway administration, under this act, any steps is to be taken, the highway administration can take it, or by an officer authorized by the highway administration.
Yes.
He can take even the help of the police.
Now regarding authorization, that part, from here it is clear that site engineer. Now the acquired is this one. The site engineer, he has been acquired there who was authorized person. That is clear. That is to be
Authorized by the highway administration. Kindly appreciate, it is not anybody else, not by the highway authority or any other, but the project director giving it. Whether he is the person authorized by the highway administration.
That is to be done. I have to.
He will be the person who can initiate proceedings under this control of National Highway Land and Traffic Act 2002.
No, now, that's what I'm understanding, Lord, I may be wrong. If we are now, suppose your lordship director, if we stand under provision of section 20, subsection 2 of section 26 of Act.
I'm not saying subsection 2.
No.
You may take action under 26.
26, if I
Which
take,
may
if I
include
take,
not only 2, also 7.
then I will definitely I will instruct them to send that particular person. If your lordship director to go for by 26, section 26 of Act 2002, then definitely we will ask. I will be in a council. I'll tell them you send the proper person as per this. They will definitely send the right person.
It's not a question of demarcation any further. You'll take it over. Okay, get hold of the police and throw him out.
Whatever arrest will not coming again, whatever it is, it will be done by proper person, proper officer. Definitely. Because they will be knowing better than me, because I'll instruct.
Because it is an admitted fact by him that he is in occupation of 2 acres, which he couldn't have.
Now only occupation is taken. Now it's to be taken by that person. That is to be.
So you require another 13 letters of land.
As per lordship direction, I'll also tell them, okay, you send the right person, not the unauthorized person. What is the right person? I'll tell them. Accordingly, they will decide. If they do wrong, it will be again problem. I'll definitely stay on that point.
One further submission.
The instant petition has been filed by the petitioner.
May I place one thing,
being aggrieved by what man?
For a moment, if you lot.
What is this?
My difficulty. This is the map of my land. For one moment, if you lot.
Aggrieved by.
License they take my which side how much that should be precise. My concern is this. Because if anything goes other way around, my lord, it affects my state and all. But how they will do it? That has to be the circle officer or the lot mandal that they have done it, have not done it properly.
If it is
But
not
I'm
done
not that
properly,
I'm
why
sure-
they have not lost the complaint at that time, Lord? After filing of the affidavit, why they have come to
By
the
this on one side and 9
Okay,
days on other
whatever
side.
may be. Let me pass the judge. Thereafter, you look whatever it is. There's a division bench sitting out there, court number 2, or
Yes,
court
for your
number
lordship, my lord.
2. The instant petition has been filed by the petitioner seeking a direction upon the respondent not to demolish the boundary wall of the factory premises of the petitioner and not to evict them from the part of their factory land without following due process. From the facts enumerated, from the facts stipulated, from the facts as could be discerned from the perusal of the pleadings, it revealed that on the basis of a deed of sale bearing deed number, what is the deed number?
Deed number, yeah.
Don't know what is the deed number. Perusal of perusal of the materials on report is that the petitioner had purchased that the petitioner number 3, along with one Suraj Kumar Agarwal and Sri Lalit Kumar Agarwal, had purchased a plot of land measuring 1 bigha 2 katha, covered by dag number 14, 35 and 36 of KP Patna number 106, situated at village Naukuchi under Moza Pub Borigog under Rongia Revenue Circle, Rongia, in the district of Kamrup by the deed of sale, registered deed of sale dated 7th of September 2007. On the same date, by another deed of sale, the petitioner number 2 had purchased another plot of land, another plot of conjoint land covered by land at measuring 1 bigha, covered by dag number 14, 35 and 36 of KP Patna number 106, situated at Revenue Village, Nakuchi, under Moza Pub Borigog, under Rongia Revenue Circle in the district of Kamrup, Assam. It is the case of the petitioner herein that the petitioner number 1 firm established a factory at the aforesaid plot of land, leaving 25 feet from the national highway. The said factory, including the boundary, as per the petitioner, was constructed in the year 2008 after getting the land demarcated from the revenue authorities. It is the case of the petitioner that on 13 2018, the circle officer, Rongier Revenue Circle, along with his staff, visited the factory premises of the petitioner number 1 and directed his officials to demolish the boundary wall of the factory. Thereupon, one of the partners of the landowner visited the office of the circle officer Rongia and submitted a representation on 14/9/2018 in the office of the circle officer, requesting her not to demolish the boundary wall without notice and without following the due process of law. However, as the respondent authorities were threatening to carry out the demolishing for widening of the National Highway number 41, being managed by the National Highway authorities, the petitioner had approached this court by filing the instant writ petition, seeking for a direction upon the respondents that the boundary wall of the factory premises of the petitioner should not be demolished. It is, however, relevant to take note of that in the instant writ petition, apart from making the state authorities, state revenue authorities a party to the instant proceedings, only the National Highway Authority have been made a respondent number 5. However, the highway administration, the highway administration, an authority constituted under the provisions of Section 3 of the Control of the National Highways (Land and Traffic) Act 2002, was not impleaded as a party. Pursuant to the filing of the instant writ petition, this court, by an order dated 15/9/2018, issued notice by an order dated 15/9/2018, directed the respondent to obtain instruction, respondent state authorities to obtain instructions, and in the meantime, directed that the status quo as on that date be maintained in respect of the boundary wall in question. The record further reveals that on 8/10/2018, notice was issued and the interim order was directed to continue. The matter thereupon has been pending The record further reveals that respondent number 5 had filed an affidavit in opposition on 21st of September 2018 through the project director, National Highway Authorities of India. In the said affidavit, from the said affidavit, it reveals that an acquisition proceeding was initiated under the National Highways Act 1956, and various lands were acquired. In respect to KP Patta number 106, which was a part of the land, an area at measuring 0.18 hectares was acquired. From the said affidavit, it is further seen that on 1/3/2012, compensation was released to the respondent number 3 in respect to land covered by DAG number 14 of KP Patta number 106 of an area of 0.072 hectares. And the said amount, the said compensation of rupees 1,50,678 was duly paid to the respondent number 3. As the same could be seen from the money received enclosed as Annexure 4 to the affidavit filed by the respondent number 5. When the matter was listed before this court on 2/8/2023, it was informed to this court. Now, this court was apprised by the counsel appearing on behalf of the respondent's state authorities that when the circle officer informed to the respondent by the counsel for appearing for the respondent's state authorities that the circle officer, Rongia Revenue Circle, with the assistance of the supervisory Kanungo, Lot Mandal and the Gambura, had carried out the detailed measurement in presence of the representatives of the National Highway Authority of India, as well as the petitioner. It was found that the front wall of the petitioners and some tin houses belonging to the petitioners had encroached on the portion of the National Highway Authority, National Highway of India's acquired land. On the very day, the learned counsel for the petitioner, Mr. R. Dubey, had also submitted that on 24/7/2023, another measurement was carried out by the National Highway Authority of India, wherein they had put certain pillars in front of the land of the petitioners. Under such circumstances, this court, for the purpose of having an effective adjudication of the matter, issued a direction to the Sub-Divisional Officer Civil, Rongia, to carry out the demarcation proceedings in respect to the land which was acquired from the petitioners in presence of the representatives of the National Highway Authority of India, as well as the petitioner, and such report upon being submitted, and such report was directed to be placed before this court. This court further directed the subdivisional officer, Rongia, to carry out the demarcations with due notice to the National Authority of India as well as the petitioners and submit the report on or before 3/10/2023. The record further reveals from the affidavit filed by the Additional District Commissioner in charge of Rongia subdivision that the joint verification was carried out on 30/9/2023. And during the demarcation proceedings, it was found that the petitioner had encroached 9 feet National Highway acquired land in the southern side and 20 feet National Highway land in the northern side, and the boundary wall of the petitioner was situated over the National Highway acquired land. The said joint verification report has been brought on record by way of that said by the affidavit filed by the Additional Deputy Commissioner in charge, Rongia Subdivision. Pursuant to the order passed by this court on 9/10/2023. And directed the matter to be listed again on 18/10/2023. When the matter was listed on 18/10/2023, the learned counsel appearing on the petitioner contradicted the report submitted by the respondent authorities to the effect that the petitioner is in occupation of any land of NHAI and sought for a recommendation to file an affidavit. And accordingly, this court directed the matter to be listed on 15th of November 2023. The record reveals that on 15th of November 2023, the petitioner filed an affidavit in reply through the petitioner number 3. In the said affidavit in reply, serious allegations have been made as regards fabrication of the signature of the petitioner in the report, in the attendance sheet. And also stated that the circle officer had signed the verification report, but was himself not present when the verification was carried out. It is, however, very interesting to take note of Annexure 1 of the said affidavit in reply, which is a communication issued dated 30/9/2023 to the circle officer Rongia Circle by the petitioner number 2 and 3. In the said communication, it was duly mention that 2 kathas of land was acquired out of 2 kathas, 2 kathas of land belonging to the petitioners. And the petitioners were in occupation of 2 bighas of land. And as such had sought for demarcation of the land. This communication is very vital for the adjudication of the instant dispute, taking into account that it is the categorical admission on the part of the petitioners that they are in occupation of 2 bighas of land. And only 2 kathas of land was handed over possession of. Taking into account that the affidavit was filed on 15/11/2023, this court and very serious allegations have been made against the officials. This court fixed the matter today, directing Mr. H. Sharma, the learned counsel appearing on behalf of the state authorities, to obtain instructions. In the backdrop of the above, let this court therefore take note of the respective contentions of the parties. Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner, submits that if the petitioner is in occupation of any further land, any land which were acquired, the same can only be, the petitioner can only be dispossessed by following the due process as stipulated, as per the procedure stipulated in the Control of National Highway Land and Traffic Act 2002. And more particularly referred to Section 26 of the said Act, which provides the due procedure of law. It is therefore the submission of the learned counsel on behalf of the petitioner that the state authorities have no business to demolish the boundary wall of the petitioner. In the manner which has been sought to be done And it is only the highway administration constituted under Section 3 of the Act of 2002 or the officer authorized by the highway administration who can act as per the mandate of the Act of 2002. That is your submission.
23, my lord. 23.
He further submitted that the highway administration, as per Section 23 of the Act of 2002, is also required to maintain record in a prescribed manner in respect to all lands of the central government. And it is on the basis of those records the highway administration or the officer authorized can act in terms with Section 26. Mr. H. Sharma, the learned counsel, appearing on behalf of the petitioner, submits, appearing on behalf of the respondent state authority, submits that the instant writ petition should have been dismissed on the question of suppression of material facts inasmuch as the petitioners have not disclosed as regards the acquisition of the land of the petitioners. It is only on the basis of the affidavit filed by the respondent number 5 that the said aspect has been brought into light. To the effect that the petitioner have already received the compensation in respect of 0.072 hectares of land. He further submits that the demarcation so carried out was on the basis of the orders passed by this court. And from the affidavit in reply filed by the petitioners themselves, it is apparent that they were very much present during the demarcation proceedings. But for reasons best known, did not sign on the proceeding in the joint verification report. He further submits on instructions that the said allegations as regards fabrication of the signature as well as the other allegations so made in the affidavit in reply are nothing but only to delay the disposal of the instant writ petition. The learned counsel further submits that if it was the case that the petitioner's number 3 signature, the factory manager's signature was at all fabricated, it is not understood as to why the petitioner, the factory manager in question till date have not filed any, lodged any FIR. Though a period of almost 40 days have elapsed. He further submits that as the land in question, as the acquiring authority, as the competent authority as per the National Highways Act 1956 is the additional deputy commissioner. Power has been vested under the National Highways Act 1956.